keep flipping back and forth.
Yeah.
I mean, she's got to get everybody, she's got to get all.
were still alive in the classroom. Video shows Uvalde Consolidated Independent School District Police Chief Pete Arredondo inside the building. He's been a central figure in the state's investigation of the shooting. At 11:58 local time, police helped the first students and teachers from a nearby classroom escape the building. 911 dispatch gives a chilling account from a student still in the classroom.
You have a child on the line.
Hey, what was that?
It's going to be room 12. I will need to see my name. He is in the room full of victims at this moment.
Yet, even with that information, 6 minutes goes by without any sort of response. Then we see Arredondo with a set of keys, trying and failing to make entry into a classroom near where the gunman is barricaded. Eventually, handing the keys off to another officer who does make entry. More time passes, then a new round of gunfire. Over the course of the next nearly 30 minutes, we see more officers arrive. Police breached the classroom and killed the shooter at 12:51 local time. By then, many young, innocent children and their 2 teachers were dead.
There's only one thing that I can tell you is there were multiple systemic failures.
More surveillance video and a 77-page report newly released to the families from the Texas House Investigative Committee details numerous failures that report finding Robb Elementary did not adequately prepare for the risk of an armed intruder on campus, adding that the entirety of law enforcement and its training, preparation, and response shares systemic responsibility for missed opportunities on that tragic day.
Several officers in the hallway or in that building knew or should have known there was dying in that classroom, and they should have done more, acted with urgency, tried the door handles, tried to go in through the windows, tried to distract him, tried to do something to address the situation.
The new information unleashing another round of heartbreak for families.
Law enforcement failed the student.
I'm Janine Stanwood, and this is the sentencing of Nikolas Cruz, the confessed Parkland shooter who pleaded guilty to 17 counts of first-degree murder. Today is day one of whether or not he will face the death penalty. And, of course, we are joined by our legal analyst, David Weinstein, former federal and state prosecutor. We certainly appreciate your expertise in this.
Thanks for having me, Janine. I hope that I can assist people understand exactly what we're going to see over the course of the next several weeks.
We expect to hear opening statements. Here we go. Let's take a listen.
Situation where it's just not appropriate courtroom decorum. So everyone, please understand that. Again, it's an open courtroom. You're welcome to be here, but please, everyone, sit quietly and do not use your cell phone unless you are part of the media and you are using it for media purposes. So media, if the staff sees you texting your friend because you're bored, that may affect your press pass. Please only use social media. Only the media with press passes can use electronic devices for the purpose of media business only. All right, at this time, okay. Where's Ann Camera? All right, Ann Camera is entering the courtroom. You can have a seat anywhere, Ms. Camera. Thank you. Go ahead and have a seat. Okay. Ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Kammer, it was brought to my attention that you may have been at an appointment, a personal appointment, a doctor's office, and that you had some conversation about the case with someone at the doctor's office sometime last week. You may or may not have known that that was not appropriate, or maybe you thought it was, sort of just superficial conversation, but I just need to find out whether or not that's true. I have an affidavit from someone at the office that recalls speaking to you about this case and about your role as a juror in this case. I'm not sure. Have you had any discussion with any doctor's employees or personnel about your role as a juror in this case?
Well, I was having an appointment that I had to cancel, and so I said that I was on the jury.
Okay. The person whose name is Jessica Fritz says that you were describing the defendant physically and talking specifics about the death penalty and talking about your feelings about the death penalty and asking her feelings about the death penalty. Actually, the person says that this happened some time ago and it was hard for her to remember the exact words, so perhaps it wasn't last week as I said that.
I don't remember describing the defendant or anything to anyone.
Okay, and ma'am, I don't mean to embarrass you at all, but I'm just gonna give the affidavit to you and let you read it and see if that's something that happened.
It's just really not true.
Okay, that's why I asked you. And if it's not true, I'm sorry to have embarrassed you or.
I'm sorry that we're going to go through this.
No, that's okay. So this never happened. Is that a no?
Yes, that's enough. I wouldn't have described the defendant or anything like that.
Did you have any conversation at all with this person, Jessica Fritz?
I don't know who she is.
Okay. And so did you have any discussion regarding your feelings about the death penalty with anyone? And have you talked about this case with anyone?
Just that I'm a juror.
And you're allowed to say that?
Yeah.
But you haven't had any discussion about feelings about the death penalty or knowing how to process how you feel about the death penalty or anything like that?
No.
And have you had any discussion about what's going on in this courtroom?
No.
Okay. All right. And do you understand my instruction that I gave about not talking about the case?
I
Okay. All right. Thank you very much, ma'am. No, don't apologize. I apologize. I had to bring it to your attention. It was my duty to do so. But if this is not accurate, then it's me who should be apologizing. Okay. Thank you so much.
Thank you.
All right, the juror under oath says that this is not true. So what are you all asking me to do?
Well, the only thing I can say is, Your Honor, that why would the person say that? I mean,
There could be a lot of reasons. I mean, sometimes people are just mean. I mean, I don't know. I'm not saying this person is, but I'm saying people say things for all different reasons. Because they want their moment of fame, because they want to put their nose where it doesn't belong, or you know, I mean, I don't know. But I certainly can't take the word of someone I've never met over a juror who I've spent hours and hours observing, who just swore under oath that this is absolutely not true.
Judge, we were under an obligation to take forward to the court.
I'm sorry?
We were under an obligation.
Absolutely, absolutely. You know, I don't have a crystal ball, but this juror has never appeared to be anything but forthcoming and honest and answering the attorney's questions and my questions, and she said it didn't happen, so I find her credible.
It's also entirely possible that unless, I mean, I don't know who she spoke to from the state, but that there's a juror with those initials.
There isn't. I went through all of them.
Different ones? Well,
there's AC, but not AK.
I was reminded of one for sure.
Possibly not a seated juror, Judge, but maybe a juror that came through.
It was our decision to, that is the correct juror. It was our decision to just.
Oh, okay, I understand.
Okay, other than that, are we ready to bring in the panel?
take a short 2-minute.
Sure, we're going to take a 2-minute recess.
Beginning, somebody brought to the attention of the court a possible conversation. What happened here?
Well, it seems from what we just heard that someone sent an affidavit to the state attorney's office saying that they overheard a conversation that a juror whose initials they gave had in a doctor's office concerning that person's ability to be fair and impartial, what their position was on the death penalty. The state was under an obligation to bring that information forward to the judge so the judge could inquire of the juror and find out whether or not this really happened. Because if it took place, that would disqualify this juror from sitting on the panel because, as you heard the judge say, they have an obligation not to discuss the case and not to talk about anything outside of the courtroom. And
well, the initial thinking was that this juror said something at a doctor's office and was this last week, but then there was a question, well, maybe this didn't happen last week. And so the judge asked the juror, and the juror then said, no, this didn't happen. I don't know anything about it.
Right. She said, that's not me. That conversation didn't take place. That's when the judge shifted to, well, maybe it happened a week before or a different point in time. And this juror flat out denied having had that conversation. So the question becomes, what's the motivation for the person who provided the affidavit? What did they hear? Who did they hear say it? And as the defense pointed out, perhaps this was another juror along the way who had not been selected, but it seems from the answers and from what the judge said, this juror said, no, it wasn't me, so we're going to move forward, and that person will stay on the panel.
And Judge Scher said, listen, I'm going to believe the answer that has been given to me under oath by this juror who I've been observing over the last few weeks, rather than somebody who just, brought this to our attention now. And
the person who brought it to their attention could have been mistaken about who the person was, about what the circumstance was, and I don't think the judge is calling that person a liar, but what the judge is saying is that I put the juror under oath, and she had sworn to tell me the truth, and she gave me the answer. And her answer, truthfully, was, it wasn't me, and it didn't happen. And so that's the way the system works. When you raise your hand and you put yourself under oath, you're going to tell the truth. And the judge said, the juror told me it wasn't her, and so I believe her, and let's move on.
So looking at that courtroom right now, we definitely saw some Parkland parents. I saw Tony Montalto, I saw Fred Guttenberg, Max Schachter. It's just hard to imagine what's going through the minds of these parents right now. This has not even started. This is day one. We expect to hear opening statements from the state. But as a parent, you're sitting there, and this is the culmination of more than 4 years. And now it's beginning today.
I think to some degree there's some relief that we're finally to this point, and that there is going to be some closure, and we're getting a lot closer to the end that we were in the beginning. I think that these parents relive every day when they wake up what happened to their child, or not a parent, to their loved one. And so this is just going to be a very emotional setting for them. And there's going to be highs and there are going to be lows. And it's going to be very difficult for them to stay composed when they're seeing this. They're sitting in the same courtroom with the person who's admitted already to having killed their loved one. And so it's going to be really tough for them to maintain the composure that they need to maintain while they're sitting in the courtroom. But again, it gives them at least some sense of we're a lot closer to the end than we were when this happened 4 years ago. And just a reminder for our viewers, this is the penalty phase. So Nikolas Cruz already pleaded guilty to 17 counts of first-degree murder, 17 counts of attempted first-degree murder. That means automatic life in prison without the possibility of parole. The jurors now will have to look at aggravating and mitigating factors to decide, should he be put to death? Right, and that's what this is going to be all about. This is what the state is going to tell us today, what they expect to be able to present to these jurors, and then these 12 jurors are going to have the very difficult task of evaluating the aggravating factors. And keep in mind, they have to establish the aggravating factors for all 17 of these victims. It's not like they can come in and make a blanket assertion. Some of the aggravating factors they will be able to say, these apply to all 17 of the victims. Others, there are going to be specific particulars that will apply to each one. With regard to the mitigating circumstances that the jurors are going to be asked to consider, those are going to be more of a general overview from the defense as to the life of Nikolas Cruz and what his mental state was at the time and his upbringing and things like that. But you're going to have 17 mini presentations within the much larger presentation of what happened to each of these victims. And that's going to be tough not only for the people who are there, but for everybody that has to listen and relive this. And if one juror does not agree to the death penalty, then that's all it takes. That's all it takes for that particular victim. They're going to have to do this 17 times, and they're going to have to evaluate the aggravating factors and the mitigating circumstances. And so you're right, Janine. If one juror says, no, I believe that the aggravating did not outweigh the mitigating, then for that particular victim, then there will be no death penalty recommendation. And in this case, of course, the judge, if they recommend life in prison without the possibility of parole, if there's no unanimous verdict for death, the judge cannot overrule that. Correct. Not the way that the statute's been rewritten in light of some Supreme Court decisions and action of the legislature. What she can override is a death recommendation. She has to reevaluate the aggravating factors and the mitigating circumstances and decide whether or not the imposition of the death penalty is appropriate for each victim. And again, she's got to do that 17 times. We are checking this out, and it looks like maybe the judge is speaking again, so let's listen in one more time. Oh, not yet. No audio yet coming from the courtroom, so we'll continue to watch. One thing that you mentioned, David, which was very interesting, so we saw Nikolas Cruz walk in. It did not appear that his hands or his arms were shackled, potentially his feet, though, however. And you pointed out one thing in the courtroom that we see these, which I never noticed, these curtains underneath the desk on both sides for the state and the defense. I think we're going back live, and I think we are. Let's listen.
State's ready, Your Honor.
Okay, let's bring in the panel, please. gentlemen, thank you so much for standing, but I think it might be a minute or two, so if you all want to have a seat, and then when the bailiff announces jurors entering, you can stand back up. We have someone who is busy.
Jurors are entering.
Good morning, ladies and gentlemen. Please remember which seat you're assigned, because that's going to be your seat for the duration of the trial. And when you find your seat, you may be seated. We stand for you.
Judge, all jurors are present and accounted for.
Okay. Madam Clerk, would you please swear in the panel?
Please stand. Raise your right hand. Do you solemnly swear or affirm that you will try the issues between the state of Florida and the defendant and render a true verdict according to law and evidence? Yes. Thank you. Please be seated.
Good morning, ladies and gentlemen. You have been selected and sworn as the jury to try the case of the state of Florida versus Nikolas Cruz. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proves the aggravating factor or factors beyond a reasonable doubt against the defendant in accordance with the law that I provide you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of our fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the lawyers. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the lawyers, the court, that's me, will instruct you on the law applicable to the case. After the final instructions are given, the alternate jurors will be released, and then the jury panel will retire to consider their verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. So even though you are now sworn, you are now a panel, a group of people who are going to essentially be coming here and hearing the testimony and evidence each day, you may not, under any circumstances whatsoever, discuss the case among yourselves until such time as you retire to deliberate. Does everyone understand? Please answer out loud. Yes. Thank you very much. Your verdict must be based solely on the evidence or lack of evidence and the law. I now remind you and instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, no text messaging, no tweeting, blogging, or using any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, you must notify a court personnel of the violation so that they can notify me. So even if it is something small or something that you think may be insignificant, you have a duty to let me know by letting one of the court staff know. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone, and I mean anyone, attempts to say anything to you or in your presence, tell the person that you are on the jury and ask the person to stop. If he or she persists, please leave that person at once and immediately report the matter to one of the court personnel who will advise me. If it's something that occurs on a weekend, you must call my office assistant, and you all have her number, and leave a message and let us know. You have to report it right away. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in court. Turned off means that the phone or other device is actually off and not on silent or vibrate. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to communicate with anyone about the case or the people involved. Do not take any photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. And we will go about, I will instruct you more on your deliberations at a later time, but I will tell you now that we'll give you a contact phone number so that if you have a family emergency or some type of emergency situation, even though you can't be directly reached, you'll be able to be indirectly reached because we'll have a number with somebody standing by to answer the phone in case your loved ones or others call about an emergency, all right? This case must be tried by you only on the evidence presented during trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any means at all to get information related to this case or the people and places involved in this case. And this applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any of the places discussed. Jurors must not have a discussion of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about the case by using an electronic device. Do not send or accept messages related to the case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on a website, internet, chat room, or blog. Now, of course, you are permitted to tell your family members or your employers that you're serving on a jury and that you're not available, and you can even give them our schedule. But you cannot talk about anything substantive or ask for advice or discuss anything other than the fact that you're on a jury and you are not allowed to tell them anything else. The reasons for these rules are because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I will have no way to make sure that the information you obtain is proper for consideration in this case. And the parties, likewise, will have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these rules jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. As you can imagine, this is a tremendous expense and inconvenience, not only to myself and to the lawyers, but to the taxpayers. If you violate these rules, you may face certain sanctions, and I'm not even going to go into those because I know you all are going to follow the rules. Ladies and gentlemen, in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the existence of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that the defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Now, in this case, the defendant has already pled guilty, but you cannot, if he does exercise his right to remain silent, you can't draw any inference whatsoever about his exercise of that right if that in fact happens. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it's made, and likewise, when an objection is sustained or upheld by me, you may not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the lawyers outside of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conferences may be required or how long they will take. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. Nikolas Cruz, the defendant in this case, has pled guilty to 17 counts of murder in the first degree in a previous proceeding. Your role as the jury in this case will be to determine the appropriate sentence to be imposed. The appropriate sentences for the crime of murder in the first degree is either life in prison without the possibility of parole or death. The attorneys will now have the opportunity, if they wish, to make an opening statement. An opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial, and this is the penalty phase. What the lawyers say during opening statement is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proven beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, 3, whether mitigating circumstances are proven by the greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after the argument of counsel, you will be instructed on the law that will guide you during your deliberations. For now, I'm going to explain aggravating factors and mitigating circumstances as I have previously. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that the aggravating factor exists. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factor or factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factor or factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. If you would like to take notes during trial, you may do so. On the other hand, of course, if you're not required to take notes if you don't want to. That will be left up to each juror individually. You will be provided with a notepad and pen for use, which was on your chair when you sat down. Any notes that you take will be for your personal use and must be taken only on your assigned notepad that was on your chair. However, you may not take the notepads with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver the notes to me and I will destroy them. No one will ever read your notes, including me. We won't read them on the recesses and we won't read them at the end of the trial. They're your notes, they're for your use, and I can promise you that no one else is going to look at them. If you take notes, do not get so involved in the note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Okay, ladies and gentlemen, at this time, both sides are going to have the opportunity to present an opening statement, and pursuant to the rules of procedure, the state goes first. State?
May we have a brief sidebar?
Okay.
Sidebar before they get started. Whoever the under just wins.
Yeah, well, so we just heard detailed instructions from the judge right now. Right now they're in a sidebar and we are expecting for the state to make their opening statement.
Yeah, and that's what should take place now. There was obviously either an issue with the way the judge read the instructions or some concern that one of the lawyers from the defense side had about the way they were read. They've gone over these instructions before the judge gave them at some point prior to today, so there shouldn't have been any surprises. Perhaps they're seeking a clarification.
I think what we're listening to right now is we are listening to Hi, we can hear you. We're sort of balancing the on-air and the online, but hello, Alexis. Nice to see you.
Standard operating procedure for any trial here. What the judge did was combine some of the standard instructions that are given in a guilt phase case with those specific instructions in the penalty phase. The things that she wanted these jurors to be aware of was their duty not to communicate with anybody about what they hear, their duty to simply listen to the evidence that they hear in the courtroom, and that's what they're going to base their deliberations on. Interestingly, they're going to allow them to take notes. That often is helpful to jurors, but sometimes presents a point of friction when they get into the jury room because a juror will...
Okay, it looks like we're going to bring in, back to the live pictures, look like they're starting their opening statements. We're going to listen in.
Goal-directed, planned, systematic murder, mass murder of 14 children, an athletic director, a teacher, and a coach. These brutal murders occurred at Marjorie Stoneman Douglas High School in Parkland, Florida, and it happened on February the 14th, 2018. 3 days before these brutal murder, this massacre, the defendant in this case made a cell phone video on his cell phone. And this is what the defendant said. Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR-15 and some tracer rounds. It's going to be a big event. And when you see me on the news, you'll know who I am. You're all going to die. Ah, yeah, I can't wait. Ah, yeah, I can't wait. Cold, calculated, manipulative, and deadly. Now, Marjorie Stoneman Douglas High School is located at 5901 Pine Island Road in Parkland, Florida. It's bordered by Homburg Road on the north side, the Sawgrass Expressway on the south side, Pine Island Road on the east side, and on the west side is Coral Ridge Drive. But if you, and you'll see a map, before you get to Coral Ridge Drive to the west, there's West Glades Middle School and then a Walmart, and then there's Coral Ridge Drive. You'll see that Marjorie Stoneman High School kind of resembles a college campus. There was approximately 13 buildings spread out over the campus. Most of the buildings were 1- and 2-story buildings, except for one. The one building that is not a 1- or 2-story building is a 3-story building, and it's known as the 1200 building or the freshman building. The 1200 building is located on the northeast side of the campus. So it's bordered on the north by Homburg Road and Pine Island on the east. It's a 3-story building, and there's 2 entrances to the 1200 building. There's an entrance on the east side, and there's an entrance on the west side. And both those east and west entrances open up to the first floor hallway. The entrances are a double door on the east side and a double door on the west side. And to the right of those double doors, there's a secondary door, both on the east side and on the west side. And this secondary door leads up into the first floor landing of the stairwell. And the stairwells go up to the 3rd floor, both on the east side and on the west side. There are 10 classrooms on each floor of the 1200 building. There's 6 classrooms on the south side of the hall. There's 4 classrooms on the north side of the hall, and that holds true for the 1st floor, 2nd floor, and the 3rd floor. And Marjorie Stoneman Douglas, back on February the 14th, 2018, had a surveillance system, and there are approximately 76 cameras that spread out through the campus. And these cameras were motion activated. And what that means is they have to detect motion before they record. So if there's nothing moving, they don't record. In the 1200 building, there were 13 cameras. There were 3 cameras on the 1st floor, 3 cameras on the 2nd floor, and 3 cameras on the 3rd floor. And these cameras are installed in the ceiling. So there's a camera on the east side in the ceiling, a camera in the center in the ceiling, and a camera on the west in the ceiling, 3 cameras. And there's 3 cameras just like that in the ceilings on the 1st floor, 2nd floor, and 3rd floor. The camera on the east side, up on the ceiling, focuses west. The camera in the center of the ceiling focuses west. The camera on the west side focuses east. And that's true for the 1st floor, 2nd floor, and the 3rd floor. And there are 2 additional cameras in each stairwell. There's one on the 3rd floor of the stairwell, one on the 2nd floor of the stairwell. And that's true for the west stairwell and the east stairwell. There are 13 cameras in the 1200 building. There are no cameras in the classrooms. There are no cameras in the classrooms. And again, these cameras are motion activated. So you will see a surveillance video from the Marjorie Stoneman Douglas High School from February the 14th, 2018. You will see the defendant on the 1st floor fire a rifle, shoot and kill 9 students, the athletic director, and a coach. And the athletic director and the coach were both campus monitors. You will see the defendant fire his rifle 6 times on the 2nd floor, and you will see him shoot and kill 5 students on the 3rd floor and a teacher on the 3rd floor. You will see him wound 13 other students on the 1st floor, and you'll see him wound 3 other students on the 3rd floor and wounding of a teacher. You will not see every single second of that surveillance video. You're going to say, why? Because it's what? It's motion activated. When the defendant fired his rifle, the percussion in the hallway was so loud that it caused the ceiling tile, the dust from the ceiling tile, to fall down. And when the dust from the ceiling, and it looks like smoke, and when it comes down, it prevented the cameras from detecting some of the motion of the defendant. But most of it is there, and you will see it. The cameras are motion activated. You will also learn that because of the percussion of the defendant firing his rifle, it also affected the fire alarm system. So at 2:20, 2:38, and I'll get back to why that time is important, this fire alarm goes off because the fire alarm system was not able to detect the difference between what? Between smoke and dust. The defendant attended Marjorie Stoneman Douglas High School from August the 15th, 2015 to February the 8th, 2017, and he was also a member of the JROTC. Let me take you back to Valentine's Day, February the 14th, 2018. A Uber stops in front of the east gate to Marjorie Stoneman Douglas High School. It's a pedestrian gate on the east side on Pine Island Road. It's a female Uber driver. The defendant gets out of the seat, the rear seat of the Uber, I think it was a RAV4, and he gets out and he's carrying a black case and a backpack. Now, school's in session. It's Wednesday, February the 14th, 2018. It's approximately 2:19 p.m. The school starts at 7:40 a.m., Marjorie Stoneman Douglas, and the last class ends at 2:40. The gates open in the morning for students to enter and go to class, and then they close. And then they open again, so right before school ends at 2:40, 20 or 30 minutes before. So what? The students can leave the campus. So it's 2:19 p.m. The defendant is carrying a black case and a backpack. And what he has in this case, is a Smith & Wesson 5.56 caliber rifle. And this rifle, it's commonly known as an AR-15. This rifle fires not only 5.56 caliber ammunition, but also fires .223 caliber ammunition. The gun will fire both. This gun is commonly known as an AR-15. It's a semi-automatic rifle. This weapon will fire as many bullets as it contains in the firearm magazine. And this is the way this 5.6 Smith & Wesson M&P 15 TF 16214 is the serial number. This is the way this gun operates. What you do is you load the firearm magazine with bullets. And the bullet is about like this for a 5.56 and a .223. And you put those bullets in the magazine, you load them in the magazine, and the bullets will go in as many as the magazine will hold. So if it's a 40-round magazine, you can stick in 40 bullets. If it's a 30-round magazine, you can stick in 30 bullets. So you fill up the magazine, and then you take the magazine and with how many bullets you have in it, and you stick it into the magazine well of the rifle. And then you pull back the lever, and you charge a bullet that goes into the firing chamber, and you pull the trigger. This weapon will fire as quickly as you can pull the trigger. And that's what the defendant had. And the Uber driver picked up the defendant to bring him to Marjorie Stoneman Douglas High School from 7200 Loxahatchee Road. 72 Loxahatchee Road was the home of Kimberly and James Sneed and their son, J.T. Sneed. J.T. Sneed was a friend of the defendants. They both went to Marjorie Stoneman Douglas High School together. They were both a member of the JROTC together. And a short time after Thanksgiving of 2017, the defendant came to live with the Sneeds. He had his own bedroom. He was attending school. He was working at the Dollar Tree. The Sneeds took the defendant in and offered him a place to live. Why? The defendant's adopted mother passed away November 1st, 2017. The defendant needed a place to live. The Sneeds made the offer. The defendant moved in with them. And it was a short time after Thanksgiving. These murders happened when? February the 14th, 2018. On this particular, and when the defendant arrived at Marjorie Stoneman High School on Wednesday, February the 14th, 2018, he had been planning to be a school shooter long before he moved in with the Sneeds and long before his mother passed away. On this particular Wednesday, on this particular Valentine's Day, the defendant gets out of the Uber. He goes through the passenger gate. He's wearing his backpack. He's carrying his black case. It was a black Cabela bag case with a rifle in it. And he walks about 360 feet from Pine Island Road to the east entrance double doors. He walks in through the east double doors, makes an immediate right-hand turn, and walks in to the bottom floor of the stairwell, of the east stairwell. He takes his rifle out of the Cabela bag, black bag, and as he's preparing his rifle to fire, in walks a student, Christopher McKenna. Christopher McKenna was a student in classroom 1216. 1216 is on the first floor. It's the second classroom from the east double door entrances. Christopher McKenna was out on the bathroom pass, and he was going up to the second floor because at the time, the first floor restrooms and the third floor restrooms were locked. And so the security could watch people go to the second floor because they were concerned about, different activities in the first floor and third floor, kids going there vaping or hiding out or whatever. So for a security measure, they did lock the bathroom doors on the first floor and the third floor. So Christopher McKenna gets a pass from his teacher. It was Miss Haas in 1216. She taught English, approximately 30 students in her class. He gets his pass, walks down the hall, bumps into a couple of kids, and you'll see the video of him bumping fists with two of the students, and he walks into the stairwell as the defendant, Nikolas Cruz, is preparing his M&P 15 rifle. And the defendant says to Christopher McKenna, "You better get out of here. Something bad is about to happen." Christopher McKenna runs out. Remember I described the secondary door that's in the stairwell? He runs out that east door and he runs to find a campus monitor. When he runs out, the defendant enters the first floor hallway. And when he enters the first floor hallway, there are 4 students in the hallway. He gets out and he fires his weapon at the 4 students in the hallway. The time, 2:21:33. 2:21:33, the massacre begins. Here's who the 4 students were in the first floor hallway. Ashley Baez was walking west in the hallway in front of classroom 1215. And let me describe what existed on the south side. You know, there's 6 classrooms on the south side. So the first classroom on the south side is 1218. The next class, the numbers aren't, consistent, but the next classroom is 1215, classroom 1215. So sitting in front of classroom 1215 is a student, Gina Montalto. And she asked permission from the teacher in 1215. By the way, it was a personalization class, so you can catch up on your homework and do different things, different from when I went to school, but you can do whatever you want in homework, whatever, like a study hall. So she asked Miss Matlock if she could go out in the hall and work on her computer because it was more private and she could get more work done on her project. Miss Matlock had offered her to go to a different classroom or somewhere else. Gina said, no, fine, I'd like to do that. So she's sitting, and when you watch the video, you'll see her legs sticking out from the front of classroom 1215. Standing next to her, knocking on the door to classroom 1215, was Martin Duque Aquilano and Luke Hoyer. Martin and Luke were coming back from, and you can get permission to go to other classes. They were coming back from somewhere near the administration building. They had to do something. And you'll see them actually coming back down the corridor and walking in. And you'll see him, Luke or Martin, bump fists with Chris McKenna. So they're standing at the door of classroom 1215 and they're knocking to get in because procedure is when class is in session, the classroom door is supposed to be locked. The defendant fires at Martin Duque Aquilano, Gina Montalto, and Luke Hoyer. He then turns and goes over to classroom 1216. Remember I described that? That's where Christopher McKenna left from. That's Miss Ha's English class, approximately 24 students in there. He fires into 1216. You'll see on all the doors in the 1200 building, there is a glass window in the metal door. And this window is approximately 8 inches wide and 42 inches long. The defendant fired through that window, shattering the window, and shooting and killing Alex Schachter, who was sitting in his desk. The defendant then turns right outside of classroom 1216. He kneels down, he takes off his backpack, unzips his backpack, and pulls out a black tactical vest. And you'll see the vest. This vest has pouches all over it, so you can stick firearm magazines in it. There were 10 firearm magazines in that black tactical vest. The defendant kneels, takes it out, puts the vest on, takes the expended magazine out of the magazine well of the rifle, and puts in a new magazine. He stands up and he walks over to 1215 where Martin Duque and Luke Hoyer and Gina Montalto were, and he fires into them. And then he fires into classroom 1214. Remember I said there's 1218, then there's 1215, and then there's 1214. And 1214 and 1215 are adjoining. Their doors are right next to one another. The defendant fires through the glass window and shatters it and fires into classroom 1214. 1214 is a class that was being taught by Ivy Seamus. She was teaching Holocaust history. He fires in to 1214, and he shoots and kills Helena Ramsey. He shoots and kills Nicholas Cruz, and he wounds Samantha Grady, Samantha Fuentes, Isabel Checker, and Danielle Menescu. He then turns away from 1214 and walks back across the hall to 1216. And he fires again through the shattered window in 1216. This time, he shoots and kills Alyssa Alfadef. He shoots and kills Elena Petty. He wounds Justin Colton. He wounds William Olson. He wounds Genesis Balancing. He wounds Kishaba Magaforian. And he wounds Alexander Durrett, the brother of Nicholas Durrett, who was shot and killed across the hall in 1214. He then turns and walks away from 1216, and he's walking west. At this time, through the west double doors comes running Christopher Hickson. Christopher Hickson was a campus monitor and an athletic director. He comes running through the west doors. The defendant sees him and fires his rifle at Christopher Hickson. Christopher Hickson is hit. He's severely wounded. He falls to the ground, and he crawls over to an alcove on the north side of the first floor hallway. The defendant continues to walk west, and he's walking west. He passes Gina Montaldo, Martin Duque Aquino, and Lou Coyer again, and he fires into them again. Then he proceeds west. Now he goes to classroom 1213. 1213 is now the third classroom from the east side. You have 1217, 1216. Remember, he fired into 1216. Now this is 1213. 1213 is a psychology class being taught by Renette Riobin. And the defendant, Nikolas Cruz, does this again. He fires through that window, shatters the glass, shoots and kills 16-year-old Carmen Shentrum. He wounds Madeline Wilford. He wounds Samantha Mayer. And he wounds Benjamin Wickander. He then turns and walks west again. And as he's walking west, he passes Christopher Hickson. And you'll see it. He turns like this and shoots Christopher Hickson again. He continues to walk west, the defendant does, and he reaches the west stairwell door entrance to the stairwell. And he walks into that door, and as he walks in that door, the outside door, remember I said the secondary door, just like on the east side, on the west side, that door opens. And who is it? It's Coach Aaron Feiss, who's also a campus monitor. Aaron Feiss is the campus monitor that Chris McKenna ran to find to tell him about what he saw. So here's Aaron Feiss opening the door. And as the defendant is walking in the first floor stairwell, he turns and he fires his rifle and shoots and kills Aaron Feiss. Aaron Feiss is shot twice in the chest. He falls right outside the class, that west outside door. The door closes, and he falls right outside that door. The defendant then goes up the west stairwell. And as he's going up the west stairwell, there are also, as I said, 10 classrooms on the second floor. Now, the teachers and the students, they heard the shots. And when the fire alarm goes off at 2:22:38, the procedure is to evacuate. No, they didn't evacuate. The defendant fired 70 shots on the first floor and 2 shots in the stairwell. So the teachers and students on the second floor, they heard that. So they didn't follow the procedure of evacuating when there's a fire drill. They fired the procedure that if there's an active shooter, you get away from the door and you turn off the lights and you be quiet. And that's exactly what the students and teachers on the second floor did. So when the defendant gets up on the second floor, he looks in a couple of the classrooms and he fires into classroom 1234 and 1231, shatters the windows. So there was nobody in 1234 or 1231. He only fired. He fired 6 shots on the second floor. And he goes to the east side stairwell to go up to the 3rd floor now. Now, the students and the teachers on the 3rd floor, they heard some noises, but they weren't distinct like the students and teachers heard on the 2nd floor of the shots being fired. So they didn't hear like gunfire, they didn't hear shots. But what they did, they were responding to the fire drill. So the classes empty out, they follow the procedures. Some are going to go down the west stairwell, some are going to go down the east stairwell. But when the kids are doing that and they're going down the stairwell, then they hear the gunshots on the 2nd floor. So what do? They race back up the east stairwell and the west stairwell, and they run as fast as they can to get back into their classrooms for safety. So when the defendant walks up the east stairwell, there's a teacher helping his students get into his classroom. His name was Scott Beagle. He was 35 years old, and he was teaching geography in classroom 1256. 1256 is the first classroom from the east side on the north side of the hallway. He has the door open, the kids are going in. The defendant pops out of the east stairwell door and fires into Scott Beagle 4 times, killing him. And he falls right in the entrance to his classroom. And next to Scott Beagle's classroom is 1255 on the north side. And that classroom was an English teacher, Stacy Lapel. And she's hustling all the kids to get into her classroom. And she was successful in doing that. But as she's the last one there to close the door, the defendant shoots at her and wounds her. And she closes the door and goes back into her classroom. The defendant continues to fire on the 3rd floor. He's firing from east to west. There are 2 girls, 2 students, Carol Logren and Meadow Pollock. They're in front of classroom 1249 on the south side of the hall. The defendant shoots both of them. And they fall and they go huddle into the alcove of classroom 1249. He fires and hits and wounds Kyle Lehman, Marian Kabachenko, and Anthony Borges. The other students are running away down the hall. They're running from the defendant. He shoots again, and he hits Joaquim Oliver, and Joaquim Oliver ran into the alcove of the men's restroom. Jamie Guttenberg was racing down the hall to get to the stairwell door, and she was shot. Peter Wang, he was doing the same thing. He was running to the stairwell door to run down. He was shot. The defendant then proceeded west again. And as he passes classroom 1249, just as he did on the 1st floor when he went by Gina Montaldo and Martin Duque and Luke Hoyer and Christopher Hickson, he fires into Carol Logren and Meadow Pollock as they were huddled in the alcove of 1249. He then leaves and moves further west. He looks into the alcove of the men's restroom where Joaquim Oliver was wounded. He was shot in the leg. He couldn't run. the defendant fires into and kills Joaquin Oliver. The defendant then turns and walks further down the hall. Jamie Guttenberg was able to reach the door, but she collapsed on the third floor stairwell, and that's where she died. She died on the third floor stairwell of that building. Peter Wang was shot, and he was lying in the southwest corner, right in front of the west stairwell door. The defendant walks up to him and fires into Peter Wang again. Peter Wang was shot 13 times. The defendant then looks out this little window in the stairwell on the west side. He turns and he walks over to room 1240. Now, 1240 is not a classroom. It's a teacher's lounge. And teachers go there, I guess, to papers or whatever they're doing, eat lunch, whatever. There's desks in there, and there's a men's room and a ladies' room in there, restrooms, and a couple other rooms attached once you go into the classroom, to the teacher's lounge, 1240. The defendant shoots the glass because 1240 had a glass just like all the other, other rooms, the other classrooms, 8 inches wide, 42 inches long. He shoots through that window and he goes into 1240. Now, when you go into 1240, there's a window on the south side looking over the campus, and there's a window on the west side looking over the campus. And they look over a courtyard, they look over walkways, and they look over parking lots. The defendant fires his rifle at the west window, and you'll see there's 5 bullet holes in the west window, and he fires 5 shots out of the south window. He then leaves 1240. He passes the body of Peter Wang. He opens the west stairwell door. He passes the body of Jamie Guttenberg. He takes off his vest, lays it down on the third floor landing stairwell, takes his rifle, lays it down, and he runs out. The defendant is wearing a maroon JROTC Stoneman Douglas ROTC shirt that students get when they're members of the JROTC. He's wearing black pants. He's wearing a dark blue baseball cap. He's wearing glasses. He runs down the west stairwell. And he runs down and runs out of the door. And he passes Aaron Price. He leaves the 1200 building at 2:27:55. He started his shooting at 2:21:33. He leaves the 1200 building at 2:27:55. He runs west. Then he turns south and runs by the tennis courts. And he runs and blends in with students and teachers who were evacuating the campus. They were evacuating the campus because they heard the fire drill. When the fire alarm goes off, it goes off through the whole campus. So they were leaving. The defendant runs and gets in with the group, and they all go, this whole group of students and teachers, out to Homburg Road to the north. They pass West Glades Middle School. They go out to Homburg Road. The defendant gets to Homburg Road. He goes west. He walks to Walmart, walks through the parking lot, goes into Walmart, goes into the Subway sandwich shop that's actually in Walmart. He orders an icy. He leaves a tip, pays for it, leaves a tip, takes his icy, walks out of the Subway, sits on a bench inside Walmart, drinks his icy, there for a couple minutes, gets up, and he leaves. And he walks over to Coral Ridge Drive, and he walks south on Coral Ridge Drive, and he walks to a McDonald's on Coral Ridge Drive. He arrives at the McDonald's at 3:01 p.m. And as he walks into the McDonald's, there's a student there named John Wilford. John Wilford was a student at Marjorie Stoneman Douglas. He's sitting at one of the booths. He is the brother of Madeline Wilford, who was shot in classroom 1213. John had no idea what was going on. He certainly didn't know his sister was shot. He's calling, waiting for his mother to pick him up, as a lot of the students were, because they had evacuated. He's sitting at the booth. The defendant, Nikolas Cruz, walks up to him and sits across from him in the booth. And when you see the video, they're going to say, hey, they had to know each other. John Wilford didn't know him. And the defendant asked him for a ride. And John Wilford says, I'm not going to give you a ride. My mom's picking me up. She's going to pick me up. We can't give you a ride. So John's mom arrives in the parking lot. John gets up. He leaves McDonald's. The defendant follows him. He goes with him. He says, hey, look, can you give me a ride? He says, look, I told you, I'm not going to give you a ride. I'm going with my mom. So John gets in his mom's vehicle. They leave. The defendant crosses Coral Ridge Drive, and he walks into an area called Wyndham Lakes. It's a development. He's walking in Wyndham Lakes. And about this time, there's an officer who's responding to help other agencies. His name is Michael Leonard. He's a police officer with the Coconut Creek Police Department. And he's looking for a white male wearing a maroon JROTC Marjorie Stoneman Douglas collared shirt, polo shirt, and black pants and a dark hat. So he sees Nikolas Cruz walking on Wyndham Lake South. He pulls him over, stops him, the police come, and he's arrested. The defendant is arrested at approximately 3:40 p.m. The location is approximately a mile and an eighth from McDonald's and 2.9 miles approximately from Marjorie Stoneman Douglas. The police and the medical examiner's office, after that, arrive at Marjorie Stoneman Douglas at the 1200 building. And this is what they find. There are 14 deceased bodies at Marjorie Stoneman Douglas at the 1200 building. There are another 2 bodies at the North District Hospital. They were Gina Montaldo, the little girl who was sitting outside with her computer outside 1215. They took her to the hospital. Gina was shot 4 times. She was 14 years old, and she died from her wounds. They also took Christopher McKenna, Christopher Hickson, the athletic director, who crawled over to the north side of the wall in that alcove. When the police came, he was still alive. They took him to the North District Hospital. Christopher Hickson, the athletic director, the campus monitor, was 49 years old. He was shot 3 times, and he died of his wounds. Martin Duque Aquillano was 14 years old. He was with Luke Hoyer, knocking on the classroom door of 1215. When the police came, they took him out, and they took him to Homburg Road and Pine Island Road to see if they could help him. Martin Duque Aquillano was 14 years old. He was shot 8 times, and he died of his wounds. And then when the medical examiner and the police came in, they saw Luke Hoyer. He had been moved by the police so students could get out of 1215, but Luke was still in the hallway. Luke was 15 years old. He was shot twice, and he died of his wounds. They went over to classroom 1216. It was Miss Haas' English class. Sure enough, Alex Schachter, 14 years old, was shot twice in the chest, and he died of his wounds. Alyssa Alfadef was 14 years old. She was in classroom 1216. She was shot 8 times, and she died of her wounds. Elena Petty was in classroom 1216. She was shot 4 times, and she died of her wounds. The police and medical examiners then went across the hall to 1214, Ms. Seamus's class, who was teaching Holocaust history. Helena Ramsey was shot 4 times. 17 years old, she died of her wounds. Nicholas Dorette was shot 3 times in 1214, was shot 3 times. He was 17 years old, and he died of his wounds. And they crossed the hall to classroom 1213. In 1213, it was Carmen Chintrum. Carmen Chintrum was 16 years old, and she was shot 3 times, and she died of her wounds. They then saw Aaron Feist, and Aaron Feist was still lying just outside the west stairwell door, just to the south of the double doors to the west entrance. Aaron Feist was shot twice in the chest, and he died of his wounds. The police had brought down, before the medical examiner got there, brought down Jamie Guttenberg from the 3rd floor landing, and she was outside just to the north of the double doors on the west entrance. Jamie was shot 1 time. Jamie was 14 years old, and she died of her wounds. There was no one that was shot and killed on the 2nd floor, but on the 3rd floor, the police found just outside his classroom, 1216, he was moved a little bit too, was Scott Beagle. Scott Beagle was the geography teacher who was holding the door open for the students. Scott Beagle was 35 years old. He was shot 4 times, and he died of his wounds. Further down the hall, right in front of 1249, the police brought the bodies of Meadow Pollock and Carol Logren out to the middle of the hall so students could get out, after this was all over. Meadow Pollock was 18 years old. She was shot 6 times, and she died of her wounds. Carol Logren was 14 years old. She was shot 3 times, and she died of her wounds. They found Joaquin Oliver. Joaquin Oliver was the boy who was shot in the alcove of the men's restroom on the 3rd floor. The police had pulled his body out into the middle of the hallway too. Joaquin was 17 years old. He was shot 4 times, and he died of his wounds. Just to the west, still lying there in the southwest portion of the hall, by the west stairwell door, was Peter Wang. Peter Wang was shot 13 times, and Peter died of his wounds. The BSO crime scene unit came, and they did their investigation. Here's what they found. There were 139 rounds fired in the 1200 building. There were 70 rounds fired on the 1st floor. There were 2 rounds fired in the west stairwell. Remember when the defendant shoots and kills Aaron Feist? There were 2 rounds there. 6 rounds were fired on the 2nd floor, and 61 rounds were fired on the 3rd floor. 51 rounds were found, casings were found in the 3rd floor hallway, and 10 rounds were fired in Teacher's Lounge 1240. They found 10 casings, the back part of the bullet. That's why I'm indicating this is what they found. As I said before, when you fire a semi-automatic weapon, a semi-automatic rifle like this one, TF-16214 is the serial number, the casing pops out when another round comes into the chamber for firing, and it falls to the ground. That's how there were 17 casings on the 1st floor, 2 casings in the west stairwell, 6 casings on the 2nd floor, 51 in the casings in the 3rd floor hallway, and 10 casings in the teacher's lounge. And of course, there's 5 bullet holes in the west window, and there's 5 bullet holes in the south window. They also found the weapon, the gun, the 5.56 Smith & Wesson M&P 15. It was laying on the stairwell where the defendant left it. Still had a round in the chamber, and it had a magazine in it, and it still had 23 rounds in the magazine. And laying next to the gun, just as he left it, was the tactical vest. There were 5 magazines still in the pouches of the tactical vest. There was a 40-round magazine that was fully loaded with 40 rounds. And these 40 rounds, all the rounds were either 5.56 or what, .223, because the defendant's 5.56 M&P 15 fires both 5.56 and .223. So there are 40 rounds in that one 40-round magazine in the tactical vest. There were 4 30-round magazines still in the tactical vest. 3 of those 4 30-round magazines were fully loaded with 30 rounds of either 5.56 or .223 ammunition. And there was the 4th 30-round magazine contained 29 rounds, not 30. They also found magazines that were changed by the defendant, discarded after he was through. On the first floor, they found a 10-round empty magazine by his backpack. Remember, knelt, took off his backpack, changed the magazine. It was an empty 10-round magazine by his backpack. In that same hallway, they found an empty 30-round magazine. And all these magazines, by the way, hold both 5.56 ammunition and .223 ammunition. They found this empty 30-round magazine. Then they found another 30-round magazine in the first floor hallway that still had 9 rounds in it, live rounds in it. On the third floor, in the hallway, they found an empty 30-round magazine in the hallway itself. And in the teacher's lounge, 1240, they found an empty 40-round magazine, empty. This is what BSO found when they were there. You're going to see that there are 7 aggravating factors applicable to this case. And before I get into that, Judge told you about the aggravating factors and the weighing process. And remember I said it's a weighing process, it's not a counting process. So there are 7 aggravating factors for you to consider. The first one is the defendant has previously been convicted of a capital felony or a felony involving the use or threat of the use of violence. That's one aggravating factor, and I'm going to talk about each one of these aggravating factors in a little bit. The second aggravating factor was the defendant knowingly created great risk of death to many people. That's number 2. Number 3, that the first-degree murder, or in this case murders, don't forget there's 17 sentences. So I'm talking about them as there's 1, there's 17. That the murders were especially heinous, atrocious, or cruel. 4, that the murders were cold, calculated, and premeditated. That the next one, the murders were done to disrupt or hinder a governmental function, to wit, schooling. The next one is that the victim was an appointed public official in the performance of their duties. Scott Beagle was a teacher. He was an appointed public official. Christopher Hickson was an athletic director and a campus monitor. He was an appointed public official, as was Coach Spice. He was a coach and also a campus monitor. And the last one was that the murders were committed during the course of a burglary. You're saying, burglary? Yeah, burglary. When the defendant entered that school without permission to commit an offense, to wit, murder, that's what a burglary is. And you can see that, let's take previous convictions. So you can, even though they're not prior to February the 14th, 2018, you can consider the murder of 16 other people, even though it's contemporaneous with the one. So if you have the murder of Gina Montaldo, you can use the murders of the other 16 victims as aggravators for that, and it would go for each other murdered victim. Okay? And the 17 attempted murder in the first degree of the surviving victims, who I mentioned their names and they were shot, can aggravate each one of the sentences for the deceased murder victims. And the other felony that you can consider, that on November the 13th, 2018, 10 months after the defendant was arrested, the defendant attacked a deputy, violently struggled and fought with him, took his taser, and there's a conviction for attempted battery on a law enforcement officer with a weapon. So they are under that first aggravating factor of previously been convicted. You'll see the evidence will show that there was great risk, obviously, of death to many people. That the murders, all 17, were heinous, atrocious, and cruel. All 17 were cold, calculated, and premeditated. And that to hinder and disrupt the school function, he entered the school, he shoots Scott Beagle and kills him, and Aaron Weiss shoots him and kills him. The athletic director and campus monitor, Christopher Hickson, they were appointed public officials. They were killed, to disrupt and hinder the school function. So they're the aggravating factors that you can consider in this case, and I submit to you have been proven, will be proven beyond a reasonable doubt. And you'll see that these aggravating factors, and listen to, and I know you will, to all the evidence. Listen as carefully as you can, and I know you will. That these aggravating factors far outweigh any mitigating circumstances. Anything about the defendant's background, anything about his childhood, anything about his schooling, anything about his mental health, anything about his therapy, anything about his care. That the aggravating factors will outweigh any mitigating circumstances. After this was all over, the police, went back and trying to do as thorough an investigation as they possibly can. They collected the defendant's backpack outside of classroom 1216. They collected this Cabela black case that he had carried his AR type rifle in. It was on the stairwell steps, on the east stairwell. And laying about 3 feet away from the Cabela bag with earbuds still attached to this phone was the defendant's cell phone, 9504-821-1107. And the police did an extraction and took all the information from the phone. There were 3 cell phone videos. And the last one, and I'd said it before, the last one was on February the 11th, 2018. Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR and some tracer rounds. I think I can get it done. It's going to be a big event, and when you see me on the news, you'll know who I am. You're all going to die. I can't wait. Those words, those actions of killing 14 children, the athletic director, a coach, and a teacher, is why we're here today. Cold, calculative, manipulative, and deadly.
Thank you, State. At this time, ladies and gentlemen, we're going to take a 10-minute break. Please remember, do not discuss the case, do not begin deliberating, and again, 10-minute break, and then we'll come back into court and finish up the opening.
Good morning, everybody. I'm Janine Stanwood, and this is the sentencing of Nikolas Cruz, the confessed Parkland shooter. I'm here with our legal analyst, former state and federal prosecutor David Weinstein. Wow, we just heard opening statements from the state, from Mike Satz. Your take?
Very emotional. As you could see from the reaction of the victims' families who were in the courtroom, this was heartbreaking for them. You could see the tears in their eyes. You could see how they reacted. And you have to think that those jurors were reacting the same way. But on top of that all, the command that Michael Satz had of the evidence that he was talking about to these jurors was just overwhelming. And that has an impression on these jurors. If that person can have such a command, and it's not just what happened. He knew the names of all the victims. He addressed them by names. He knew where they were shot and killed. He knew what it was that Cruz was doing, how he prepared, the number of shots he fired, the classrooms he was going into. These jurors have to sit there and think, if that person has such a command of this and can tell us that without looking at his notes, without referring to anything else, then this is a very important time and a very important day, and we should pay as much attention as he did to get ready for this.
Did we ever. I mean, listening to this and watching Michael Satz's opening statements, and then, of course, there were some cut shots in the audience. Tony Montalto listening, Michael Satz describe her being in the hallway and her being shot, the names, the ages, zero notes, as you mentioned. And he then, of course, then at the end kind of wrapped it up and said, these are 7 aggravating factors that we believe that we can prove, that we are proving beyond a reasonable doubt, that would outweigh any mitigating circumstances in this case.
And he said it. That's why everybody is here today. The fact, and he really harped on cold, calculated, and premeditated, and he was able to establish a lot of that. Again, these are just opening statements. They're going to have to present evidence to the jury to back up what it is he's talking about. But the way he went through not only the planning, and he closed with the defendant's own words in that video that he taped on the 13th about how he was going to kill a certain number of people, how you would all remember that I was there when it happened, and that he tied that back into what he talked about, cold, calculated, premeditated, the way that he loaded the magazines, the fact that he had 5 magazines left, the number of shots he emptied, the way he killed these people, the way he talked about how some of these victims lingered. That is what the state's going to show to these jurors to prove to them that the aggravating factors far outweigh any mitigating circumstances.
And just again to remind our viewers who are watching, Nikolas Cruz already pleaded guilty to 17 counts of first-degree murder, 17 counts of attempted murder, and now this jury has to decide whether he will live or die. If they cannot be unanimous, then it will be life in prison without the possibility of parole.
Exactly. And, you know, as you're going through the number of convictions that he already has and the number of people that he's admitted to killing, as Michael Satz pointed out, the jurors can use those as aggravating factors. The death of the first victim can be an aggravating factor as to the death of the others, the way that these people died, the fact that he's pled guilty not only to the homicides, but also to the attempted homicides. And then he also pointed out the attack on the jail guard as yet another aggravating factor. Now, that one is going to work in 2 different ways. One is this aggravating factor because it's a conviction that occurred, but second, this shows what his state of mind was not on the time that it happened, but several years later. And so all the arguments that the defense is going to make about his mental state of mind, about how he was developmentally challenged and everything else, they're going to point back to that and say, well, not only did it happen on the date back in February when this happened in 2018, but he still harbored the same actions and the same way of thinking many years later. So that's going to be a double-edged sword for the prosecution to use against him and to establish these aggravating factors.
I can't even imagine what these parents are going through. They're listening to these opening statements. They're listening to Michael Satz sort of recounting in very good detail about what's happening. And this is just day 1. So we're going to toss to a quick break, and we'll be right back. I'm Janine Stanwood, and this is the sentencing of Nikolas Cruz, the confessed Parkland shooter. I'm joined with David Weinstein, former federal prosecutor. You've been our legal analyst. Thank you so much for joining us. There's sort of a lot to talk about. This is day one, and we heard, of course, the opening statement from Michael Satz, the lead prosecutor.
A very, very, very impassioned opening statement, and one in which, as we talked about before, he had the ultimate command of the facts here. And again, that's not to be lost on these jurors. If this person who's telling us why they believe that the defendant should be put to death can have a command of those facts, then we should pay as much attention as he has to get ready for this.
Now, of course, he painted a picture with his words, with his command of names and ages, and how Nikolas Cruz, he described, was able to sort of load his gun and the type of weapon that he used, how he was able to put that tactical vest on. The question, of course, is what about video? And you were mentioning that Satz brought up the fact that, yes, there is some video that jurors may see, but they may not see everything.
And one of the things now that's become more difficult in cases that are presented to jurors, they expect to see a video of everything that took place. Look, everybody has a cell phone. Every cell phone has a camera in it. There are security cameras. It's one of those, if there are no pictures, it didn't happen. And he made it a point to tell them, you'll see some video, but you're not going to see all of it. And that's not because the video doesn't exist, but because certain things happened that hampered the video that's coming through. And so that's something that they'll pay attention to, and now they won't expect to see coverage every second of what took place, and they'll be able to analyze the video they do have to establish some of these factors.
What a thing for these parents to be in this courtroom, to listen to those details, and to be in there with Nikolas Cruz. A lot of times when we looked at the camera shot, he was not facing the people in the courtroom. He was not facing those parents. He had his head down. He really was not saying anything. He appeared to sort of be fidgeting with his hands. His defense team sort of stoically sitting around him. And the question will be, of course, will they then present their opening statements as well, or will they waive that? We don't know yet. Christina Vasquez is in the courtroom as well, and she's been watching, but at this point we don't know, right?
That's their choice. They can either choose to present their opening statement now, or if they want, wait until after the state's completely done. There's pros and cons on both of those. If you wait till the state's completely done, you can incorporate some of what you've already heard into your opening statements. But on the other hand, if you don't say a word between now and then, despite the fact the judge has already instructed the jurors that the defendant is under an obligation to do nothing, they want to know, what are you going to tell us? They always are inquisitive about what it is we're going to hear from the defendant, despite the fact they've been told you don't have to hear anything from him. So it's a careful balance they have to take between, do we want to talk now or do we want to talk again? So we'll find out.
And another thing to remind people is that the jury will see what they see, but the judge just ruled last week that we, the public, the media, because of the graphic and gruesome nature of some of the evidence, we won't be seeing everything, correct?
Right. There are just certain things that are just not things that should be seen by people who are outside of this courtroom. There are privacy issues regarding the victims and who should see these photos and what took place. And quite frankly, a lot of what they're going to present is just awful and gruesome. And for people who have not been involved in the system and don't see things like this on a daily basis, it's just shattering to you to have to look at these images.
Christina Vasquez is in the courtroom right now. She was saying that she heard a couple of parents, she heard their cries. One parent left the courtroom. We saw Tony and Jennifer Montalto when Mike Satz was describing what happened to their daughter. They just closed their eyes, and it took them to this awful place. And I can't imagine. It was emotional for the two of us to be listening to it. And I'm just a reporter, and you're an attorney, and these are people who have been living with that horrible pain for the last 4.5 years.
I can't imagine the pain and the anguish and the suffering that they go through. To have lost a child, to have lost a brother or sister in a fashion like this, and now to have to hear it again. It does have somewhat of a cathartic effect because you know you're finding your way towards the end of this horrible, awful road. But to sit there in the same courtroom as the person who did this to your loved one, it has to have the impact that you just talked about. I'm really surprised that they were all able to maintain their composure and keep it together. Very difficult.
Jennifer Montalto, we saw at one point she was in tears as well. Parents, some of them have spoken publicly over the last few days. Many have said to me in conversations that they've wanted to keep a low profile during this trial. So many of them, as you know, have turned to activism, but now many of them say that they want to keep a low profile. They want to focus on what's happening, but most who have spoken publicly, when asked what is the appropriate sentence, they have either said directly or indirectly that for them it is death, whatever that means. We heard yesterday on This Week in South Florida with Michael Putney and Glenna Milberg, we heard Joaquin Oliver's dad Manny saying that death may not even be enough, but if that's what it's going to be, then that's what he wants.
For every victim who I've spoken to, both as a prosecutor and as a defense attorney, that is the resounding answer for these people. Their loved one's life has been taken away, and to them, the only appropriate punishment, save a very few rare exceptions, is that the person who did this to their loved one should suffer the same fate, that anything less than that is not enough for them. And there are people who differ and disagree on the death penalty and the way it's administered in this country, and whether or not it really has a retribution or whether or not it has a deterrent effect. But from these people, from the victims, it's all about getting closure, and for them, the only way to get closure is for what happened to their loved one to happen to the person who did it to them. And you can't blame them for taking that position, whatever your position is on the death penalty.
And to remind our viewers, so jurors will be listening to the state's argument, they will be listening to the defense's argument. This is not a determination of guilt or innocence. That's been determined. He's pleaded guilty, but this jury has to be unanimous, and they have to consider all 17 victims in this case.
They're going to need to go down that list that you heard Michael Satz go through, and they have to consider for each one of those defendants individually, one at a time, for the defendant, what happened to those victims, and did what the defendant did to those victims individually, did that qualify as an aggravating factor outweighing mitigating circumstances? And so it's going to be hard enough for them to listen to what takes place here, but then they're going to have to go back in the jury room, and they're going to have to look at the first victim and decide death penalty or life imprisonment, and then repeat that 16 times.
And there are 7 aggravating factors that Satz listed, previously having been convicted of murder, and of course that's taking into account all 17 victims, great risk of death, heinous, atrocious, cold, calculated, premeditated, which is, I think, what the state set up to at least open with today, because he went through the sort of the path of the shooter and what he did, and that was part of that argument today, that it was done to disrupt a function, i.e. school, that the victim was a public official, i.e. the coach and the teacher, and that the murders were committed during a burglary. Don't forget, Cruz was a student, and then he was not, and then he was expelled. So this was not his school. This was a place where he went in to specifically commit these crimes that the state is saying.
Whether it was his school or not, he had no right to be on the school premises at that point in time, and by breaking onto and into the premises and committing these murders, these attempted murders, he's committed a burglary, and that's not lost on the state as establishing that 7th factor. The ones that Satz really set up in great detail was just how cold and calculated and premeditated this was. To go back to the videos that Cruz taped before this was going to take place, the preparation that he had to go through in getting an Uber on his way there, the fact that he had a disguise for himself to wear so that he could escape after he did this, the number of magazines that he had loaded up, the ones that he had used, the choice of the weapon, and the way he hunted down his victims during the course of time that he was engaged actively in shooting these innocent people. That is what they're showing goes towards these heinous, atrocious, and cruel, cold, calculated, premeditated. The other factors that sort of spill over onto everything else, those are just standard statutory factors, and certainly I don't think there's any question about that. But the things they're going to continue to hammer on are the method that he planned to do this, how he carried it out, and what he did immediately thereafter in his route to escape. He recalled the conversation that Cruz had with his former fellow student in McDonald's, trying to get a ride out of there.
Right.
So these are all things that the jurors are going to have to consider.
Right. He went to that Walmart, went to the Subway first inside there, and then to McDonald's, wearing that MSD colored shirt from when he was a student. Now, the prosecution, of course, is saying that those factors will outweigh any potential mitigating circumstances. So what could the defense potentially talk about?
Well, Mr. Satz talked about some of them himself. Talked about his age, that being Cruz, his mental state of mind, any sort of biographical data about him that they're going to try and present as to his upbringing, as to his mental condition. That's what they're going to factor on. Primarily, it's going to be his age, and then growing up, what happened to him, even as far back, and we've heard some evidence that they want to introduce as to his mother and what she was doing, while she was nurturing him.
His biological mother.
His biological mother,
yes.
Not the people who he lived with, but the factors involved in his not necessarily his conception, but his development as he was in the womb, and that's what they're going to factor in on, because those are the best arguments they have in terms of any mitigating factors. Now, the state's position, and quite frankly, from hearing their opening, is going to be that those are pale in comparison to the aggravating factors that they have, and certainly not are going to outweigh to the degree necessary for any juror to decide that this should be a life sentence.
And so right now, I know that the court is in a 10-minute recess. They will come back, and I guess the big question is, what will we hear next? So if the defense waives their opening statements, then what happens?
State begins to present their evidence. They're going to call their first witness. I don't know what this first witness is going to testify about, but certainly given the way that the opening statement was structured, I don't expect it to be specific testimony about a particular victim. I think that it may be some of the groundwork to lay for the introduction of the video surveillance tape that we heard about. Perhaps start off with the Uber driver and the way that he got there, some other evidence that supports, again, this premeditation. Whether or not the defense has stipulated as to the introduction of the videos that were on Cruz's phone, so they may lead with some of that. But again, it's going to be the same methodical way to establish to these jurors, this is what happened. We're going to show you as much as we can as to what happened overall, and then individually we're going to see what happened. And they'll weave into that any expert testimony from medical examiners about cause of death, because again, that goes to how much suffering did these people go through as they were being shot at, as they were dying, and how that's going to weigh into how they died and how cruel this was to all 17 of these victims.
And then how do victim impact statements play a role in what the state will do? Because the question is, will some of these parents speak? Will these family members speak?
I have to believe that we're going to hear from one relative of each of these victims. And the state's entitled to do that under the statute. They have to establish first that the aggravating factors exist. And once they've established that those aggravating factors have existed, then they're entitled to introduce testimony about the individuality and uniqueness of each of these victims and what the loss of this victim has meant to the community, meaning their direct family, as well as the community who are part of where these people lived. And because of the young age of some of these victims, there's going to be a lot that these next of kin can talk about what they were going to do with their life, how they were going to go forward. We know that one of the victims was already actively involved in a military career. He was posthumously inducted into West Point, and so we're going to hear about all that. And that goes to the victim impact statement. As to the adults who were killed, how their loss is going to affect the students and future students who were there. And so though, again, once these aggravating factors are established, the state's entitled to introduce this victim impact statement. They can't talk about what penalty they think is appropriate, but they can talk about what was lost by the death of these victims.
Peter Wang shot 13 times and inducted into military academy posthumously, which is really just something else to listen to. Mike Satz's opening statements going through each of these victims. So he did a little bit of that as well, talking about these students. And of course, if parents or loved ones were to speak, that would just sort of add to the heartbreak and to the anguish of all of this. There's been a lot of talk about the length of this sentencing phase, and there have been at least 1,300 witnesses, I think, about 1,000 on one side, 300 on the other side. This does not necessarily mean that all of these people will speak in court.
No, it doesn't. But you have to list every witness who you intend to call so that neither side is caught by surprise. And if you wanted to take their deposition, you're entitled to set them and take their deposition. But you have to call your witnesses from your list that you've submitted. And so this prevents any surprises. The defense can't say, oh, we didn't know you were going to call this witness. But no, they're not going to call all 1,300 of these witnesses. I mean, the best example I can think of is one that we all often use during jury selection. If you were at a football game with 75,000 people attending that game and something awful happened in the middle of the field, you wouldn't expect the prosecution to call all 70,000 people.
Right.
You would call enough people to establish whatever it was the state was trying to prove. And in this instance, of those 1,000 or 1,300 witnesses, they're going to call enough of those witnesses to establish the 7 aggravating factors, but not all 1,300 of them.
This jury has a lot to consider, and in the very beginning, before opening started, there was a little bit of confusion. There was somebody who had brought an issue up to the judge who said one of these jurors had been speaking about the trial and about her feelings on the death penalty, which sort of kind of threw things. Well, first of all, it made everything start late,
right.
And we don't really know what actually happened. But the judge ended up asking the juror, you know, is this true? Did you discuss this? And the juror said no, and the judge took her at her word.
And she had to. I mean, part of the whole system is that when you come in to testify, you raise your right hand and you swear or affirm that you're going to tell the truth. And in this instance, the juror was brought in, she was told about the allegations, and the judge said, okay, they didn't happen, let's move forward.
Right. Well, and I think we're looking at the courtroom right now, and it looks like maybe things are about to start, maybe not. We'll continue to listen. But, you know, this phase right now started today, again, a little bit late because of that one juror. And then, of course, we heard the openings from Mike Zatz, the lead prosecutor. Everybody's putting their headphones on now. So what does that mean for our viewers? What does that mean that they're wearing their
I
headphones?
suspect that means she's going to ask the defense, are you going to do an opening statement, or are we going to proceed right to the evidence that the state is going to present?
And so this is a procedural issue, not something that's discussed in open court. This is really more of a sidebar.
Correct. And, you know, traditional sidebars would have been everybody marching up to the side of the bench, and they would have had a conversation, and they would have sat back down. But much easier now with technology for everybody to put on the headsets, have whatever conversation they're going to have. There's white noise in the courtroom so the jurors can't hear what's going on. But I do suspect that what they're asking now is, defense, are you putting on an opening statement? If so, how much time do you need? And if not, state, who's your first witness? And are we going to call them now? Are we going to take an early lunch break now and then come back after the lunch break? I don't think that there are any evidentiary issues that came up during the opening statement. There were no objections that were lodged by the defense, and now we're all going to find out, maybe. Nope. Looks like they're putting the headsets back on again.
Headsets back on. All right, they're continuing to discuss.
One of the things you asked me earlier, Janine, was in some of the shots you can see that padding and the curtains that are down below the desks that everybody's sitting behind. Mm-hmm. A defendant is presumed innocent in a traditional case. Here he's already pled guilty, so he's no longer presumed innocent. But it looks like they took the headsets off, so we might hear what's going on.
We might.
But again, the reason those are down there is he's probably got leg irons on. And so they don't want the jurors to see that he is considered some sort of either danger in the courtroom or a risk of flight to run out. So they put those curtains down across the front of everybody's desk so we can't see anybody's feet. Obviously, we saw Mr. Satz's feet when he walked out to talk to them. Of course. But while they're sitting there, you can't tell whether or not he's shackled or not shackled. Again, I'd have to believe that he probably is. But it's part of this umbrella of protection that they put around a defendant.
Who dresses the defendant? Who dresses Cruz?
His lawyers have decided what it is, along with him, what he wants to wear. They put him in a sweater, which many feel is going to have this sort of calming effect. We've seen that in other trials where other defendants have put on sweaters or sweater vests. They try to get a defendant to engage with them to sort of be a calm person who's listening, paying attention to what's going on. It's all part of what takes place in the courtroom because as lawyers, whether we want to admit it or not, from the moment we walk into that courtroom and start a proceeding, the jurors are watching us, and they are paying attention to everything from the clothes you're wearing to the way you present yourself, from how much attention you're paying to what's going on, because that's part of what they use to decide, who do I believe? Because yes, we listen to evidence as jurors and we hear what's being said, but it's the prosecution and the defense, or the plaintiff and the defendant. In civil cases, those are the people who are pitching their case to us. And so do we like them? Do we believe them? What kind of rapport can they establish?
Which, of course, was, I would imagine, a strategy of the state having Michael Satz go up there with 0 notes, knowing details and names and ages and just absolute, details of what actually happened. So that's believable. You can't make that up.
No, a strong command of the case. And again, it shows just how much dedication and attention he's paid to what goes in here and what he's presenting to them. And the impact that has on the jury is, if that person can have a grasp of those facts, then we need to pay attention. And we should pay attention to every word that he says or the other people working with him say. And to some degree, they're now going to compare that to the defense. Looks like the juror's coming back in the room now.
Here we go. Let's listen.
Okay, you all may be seated. The jurors are present, the attorneys are present, the defendant is present. Is the defense ready to proceed?
Your Honor, at this time, the defense would reserve their opening statement until our case is chief.
Okay. Are you all ready to call your first witness, or did you plan to do that after lunch?
After lunch.
Okay. Ladies and gentlemen, we're going to have an early lunch break today. We're going to be in recess. Well, it's not that early. It's 11:52. So we're going to be in recess until 1:15. So the deputies will walk you out. Please remember not to let anyone approach you. Nobody should approach you, but if anyone approaches you and tries to talk to you, please let them know that it's not appropriate, and please report it. Please do not begin deliberating or discussing anything that you've heard so far. You all are welcome to obviously socialize together, have lunch together, and you can talk about anything you want, as long as it does not have to do with what goes on in here or this case. Other than that, have a nice break. If you would just please be back at 11:15. That gives you about an hour and 20 minutes. The Sheriff's Office will let you know exactly where they want you to report, because they'll assemble you together as a group, and then they will bring you back in. And we will start with the testimony.
Okay, we're back. They will be taking a break until 1:15, and so the defense decided to waive their opening statements.
Not a complete surprise, Janine. I mean, given the amount of time that's going to pass between the prosecution's opening statement, the presentation of the evidence, and now they've requested a delay of almost 45 days in between the close of the prosecution's case because of an issue with one of their experts. There are also some evidentiary rulings that the court has to make in the middle. I think that their feeling is, look, the prosecution has presented this horrible picture of our client during their opening statement. What can we really do to put a dent in that now? Let's save that. Let's wait until we get a chance to speak to the jurors before we present our case, and that's when we will incorporate. It's almost going to give them an opportunity to do 2 closing statements, because they'll be able to give a rebuttal to some degree of the evidence that the state has put on during the course of the proceeding, and then in opening, the same overview of what they intend to introduce during the course of their side of the story and what it's going to show. And the jurors, in their mind, are going to have forgotten whatever it was they were going to tell them now, a month and a half from now.
And so we come back at 1:15, and that's when we expect to hear the first witness presented by the state.
Correct. And again, it could be anything from somebody establishing how Cruz got there, somebody introducing the videos that they're going to show about what took place when he arrived, some sort of laying the foundation witness for this. I'm not sure how much the defense is willing to stipulate as to the authenticity, evidentiary rulings that have to be made. So we're going to hear from somebody. I don't think it'll be anyone related to cause of death of anybody. I think it's going to be some more background and moving in a fashion where they lay the foundation for what it is they're going to present to these jurors.
A powerful opening statement by the state. And of course, at 1:15, we'll be back and we'll see who the first witness is in this very first day of the sentencing of Parkland shooter Nikolas Cruz. I'm Janine Stanwood. This is David Weinstein, who's joining us as our legal analyst. We will be back. We'll see you.
Upper 80s, Miami and Key West, thanks in part to that south-southeast wind, a really warm wind flow coming at around 10 to 15, even 20 miles per hour near Hollywood Beach. So it is a very steamy day out there. Notice the feels like temperature in Miami Beach right now is 111, extremely hot. 108 is what it feels like towards Pompano Beach, 109 in Homestead near Pembroke Pines. Good afternoon to you. It's about 103 as it feels like temperature. And these are expected to climb a little bit more as we enter the 2 or 3 o'clock hour. So if you do want to head out to the beaches today, it'll be a wonderful day to do so. However, with all of that heat, you're definitely going to need to stay hydrated, as you'll get dehydrated very quickly in all of that sunshine. We also have a moderate risk of rip currents for your swimmers out there because of that onshore flow. It's been trying to spit out a couple of showers mainly towards northern Broward County, but we are starting to see that shut down. Notice on Coral Springs, right along the Sawgrass Expressway near where it bends to the east, we're seeing a good little downpour. Also one that was just over the BB&T Center, now that's continuing to shift off. And a little downpour over 595 near Flamingo Road. That's going to make its way towards the Sawgrass Mall over the next 5 to 10 minutes or so. High temperatures this afternoon reaching those low 90s area wide, but those feels like temperatures will remain in the 100-degree range. And we'll see a couple of spotty showers trying to develop to cool us off. And notice most of them are in our inland neighborhoods as the sea breeze develops. As we enter the evening commute, some of them might try to back build towards some of our neighborhoods. So we'll keep a spotty shower chance through the early evening. And then we'll see a quieter pattern as we enter the overnight hours into your Tuesday. As we enter Tuesday and Wednesday, a batch of Sahara and dust moves in, so that's lowering the rain chance. And yes, Christy, even heating us up even more with those temperatures in the low to mid 90s.
Oh, that dust does a number on my allergies, too. Get the Claritin out. Ahead here at noon, an update after a sudden snatching that was caught on camera.
The arrest after a thief pretending to be a buyer runs off with an iPhone.
Coming up on GMA3, we're talking to the senator from Connecticut who's been leading the charge on the fight against gun violence.
Also, it's Money Monday around here. We have an expert showing us how to save big on kids' sports.
Plus, we have some tips on getting that perfect Zoom background straight from the experts.
And then we're talking to legendary singer and actress Melba Moore, who's about to receive a few major honors. All this coming up on GMA3.
New at noon, there's been a break in the case after a woman used an app to sell her iPhone. A thief pretending to be the buyer ran off with it.
The victim was then dragged with his car outside her home. Local 10 News reporter Andrew Perez joins us from North Miami Beach.
And that's exactly where the person with the crime was actually caught on camera. Is that right?
That's right, and here's the thing, we aired the surveillance video last week. The response was huge. So many people started calling police saying they know the guy that was caught on camera. Police making an arrest, and he's 17 years old, facing a felony charge of robbery. Police say the guy caught on camera is Jaeger Bonilla.
I was just in disbelief that this just happened to me, and I said, no, they're not gonna get me for this.
We spoke with the victim last week. She says she met Bonilla through the marketplace app OfferUp, and no surprise he was under a fake name. Police say he contacted her looking to buy an iPhone 12 Pro Max that she was selling. Bargained down to $750 for the phone. She felt safe, gave her address, and set up a time for the exchange when he snatched the phone and took off, the driver running over her foot.
There was something like off, so that's why I said to him, can you step out of the car? While I was looking through the phone, he snatched the phone out of my hands.
So after the story went viral all over Local 10, the right tip came in, people identifying Bonilla through the video and quickly calling police. The victim telling us this was a tough lesson learned, but she's thankful he's been caught and wonders how many other people may have been victims too. So there were actually 2 other people also in that getaway car. It's very possible they could be facing charges as well. But right now, Bonilla is the only one that was arrested. He was actually arrested at his home in Miami Gardens. That's the latest here in North Miami Beach, though. I'm Andrew Perez, Local 10 News.
All right, thanks for that. New details after a man is found dead in a lake. This happened in Weston over the weekend. Loved ones identifying that victim as 46-year-old Jermaine Jones. Authority also pulled out a 3-wheel motorcycle that he was riding. The victim's brother tells us he drove into a median and lost control, crashing into the water. Jones was a father of 2.
Police officer came to the house this morning and said he had ran into, I guess he didn't see one of those medians, and he had ran into one of the medians. And when he ran into the median, I guess he lost control.
The victim's brother and family visited that crash site. It was just south of I-75 near Bonaventure Boulevard. Also caught on camera in Miami Beach, a driver being held at gunpoint by officers, taking off and ignoring those officers' commands as well. The video shows Miami Beach police trying to stop that driver on MacArthur Causeway. Guns were drawn, orders given. The driver of that blue Mustang, though, maneuvers through traffic and leaves. Officers follow, but it's unclear if that driver was eventually stopped. We did reach out to Miami Beach police, and we have not yet heard back from them.
A car shop going up in flames in Hialeah. The fire broke out yesterday at an open-air mechanic shop near East 10th Lane and 45th Street. The smoke could be seen from miles away. Officials say the inferno was so intense that multiple agencies had to work together to put out the flames. About 15 to 20 units battled the fire from the air and the ground for more than an hour before they were able to put it out.
I believe the county unit, believe it or not, was close by. They saw it and they came to help out, and they were very helpful. They helped us protect that exposure.
Hialeah Fire Rescue says surrounding homes had their power turned off as they worked to contain the flames. Fortunately, no injuries were reported. The cause is still under investigation.
A major traffic alert right now. The turnpike closed in Northwest Miami. Let's get right over to our Local 10 traffic reporter, Andrea Martinez.
Christy, Geo, South Florida. This accident just coming in. It is shutting down the Florida Turnpike on your southbound lanes in Northwest Miami-Dade. This is due to a tractor trailer. You can kind of see it here. It's in the middle of the road, blocking things completely on those southbound lanes. So I'll show you what this looks like on your maps, because if you're headed in that direction or plan to head in that direction this afternoon, you will not be able to get by. So anywhere from I-75 to Okeechobee, US 27, it is completely shut down. You'll be stuck in bumper-to-bumper traffic. Your speed times on those northbound lanes also slowed down as people kind of slow down to check out the scene. 10 miles per hour is what you'll be traveling at. My advice to you instead, why don't you go ahead and take the Palmetto headed southbound instead, if that's a part of your commute this afternoon. Want to tell you about one thing happening in Broward County before I go. It is on the Kinney Tunnel is shut down between Southeast 7th Street and Broward Boulevard. This runs through Friday. You will not be able to access it. As an alternate, take Andrews Avenue. Guys?
All right, sounds good. Thanks for that. And ahead right here at noon, another mass shooting here in the United States.
The latest on the gunfire that erupted at a mall, killing 3 people.
Developing right now, another mass shooting happening over the weekend, this one at a mall in Indiana.
3 people were killed in that gunfire. Local 10's Andrea Martinez is in the newsroom with who stopped the gun.
Christy Gio, yet another tragedy. 3 people dead. It could have been worse had it not been for a legally armed bystander who stopped that gunman. That man now being called a hero.
Victims are possibly in the food court.
Overnight, a deadly mass shooting just outside Indianapolis, leaving 3 people dead and injuring 2 others, including a 12-year-old girl.
Let's go ahead and declare this a mass casualty.
A Good Samaritan being hailed a hero after he shot and killed the shooter with his own gun.
Heard the gun start pop, 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 pop. I don't know, a good 25, 30 shots, and my couple guys I had up front hit the deck.
Police say the heroic 22-year-old man who stopped the shooting was legally carrying a firearm.
The real hero of the day is the citizen that was lawfully carrying a firearm in that food court and was able to stop this shooter almost as soon as he began.
Cell phone video capturing the chaos inside the Greenwood Park Mall. As police rushed to the scene and were assessing where the gunman was inside the mall.
Take it slow, a little more methodical, store to store.
Store employees helping customers flee for their lives.
The only thing running through my mind, the only thing I hear right now are the gunshots, those 4 gunshots. Before I started running, there were shoes, carts, strollers, literally anything you could imagine was on the floor just tossed because you knew just people had dropped and ran.
Just such a terrible experience for all of those people. Now, all of this is still under investigation. An exact motive remains under investigation as well. As for that 12-year-old girl, she is expected to recover. In the newsroom, Andrea Martinez, Local 10 News.
Andrea, thank you. Now to the new scathing report out on the Uvalde school massacre. Texas lawmakers finding systemic failures in the law enforcement's response. That report says hundreds of officers failed to confront the gunman who killed 19 children and 2 teachers.
Oh, shots fired! Get inside!
In newly released body camera footage, we're getting a closer look at what happened inside Robb Elementary School the day a gunman opened fire, killing 19 children and 2 teachers. The footage was made public by the mayor of Uvalde after a scathing 77-page report by a Texas House Special Committee, finding catastrophic lapses in training, preparation, and leadership.
If there's only one thing that I can tell you is there were multiple systemic failures.
Just minutes after the gunman entered the school, police were on scene.
Am I bleeding? Am I bleeding? Am I bleeding? My wife's classroom.
Officer Ruben Ruiz among the 376 law enforcement members who responded. He's in the hallway while his wife, Eva Mireles, a teacher, is in room 112 texting him. The shooting rampage lasted 77 minutes before Border Patrol agents breached the classroom, killing the gunman. The report investigating the incident noting why it took so long to take the shooter down, finding egregious poor decision-making on all levels.
The report says if you're not willing to put the lives of the people you serve, of those children, before your own, in my view, you should find another job.
School District Police Chief Pete Arredondo testifying that they prioritize getting children evacuated over approaching the attacker.
We need to get these kids out of here. Come on, kids, come on.
Dispatch in the video is heard telling officers there were survivors, but it would be at least 47 more minutes after the first 911 call before they finally went in. The committee stating, quote, "It is plausible that some victims could have survived if they had not had to wait 73 additional minutes for rescue." The report also says the school's alert system was delayed due to Wi-Fi issues and that none of the 3 exterior doors to the school's west building were locked, giving the shooter easy access. All of this new information giving families more answers from that tragic day, but it's not any less heartbreaking.
She was just an awesome person. She was the light of my life.
A possible motive was also revealed in the report. The shooter was a former student at the elementary school and attended 4th grade inside room 111. His former teacher testifying he was bullied that year. Meanwhile, a lot of the families are calling for the officers to be charged criminally. Right now, though, that's in the hands of the district attorney, and so far, she continues to say this is under investigation, not adding whether they could or would be charged in the future. And coming up for you, a significant day here in South Florida, a testimony scheduled to start in the next hour in the Parkland school shooter's penalty phase trial.
And we're going to have special team coverage on air and online at local10.com for that. Time to check stocks here as we start the work week. We ended on a high note and we are up in the green on this Monday. I don't want to jinx it by being too excited about that, but it's good to see that we're up over 31,445 right now. And as you know, jury selection is underway in the highly anticipated contempt of Congress trial of close Donald Trump ally Steve Bannon. He's facing criminal charges now for refusing to comply with a subpoena from the congressional committee investigating the deadly January 6th Capitol attack. Jay O'Brien is reporting for us from Washington today.
Steve Bannon, a close ally of former President Trump, arriving in Washington, D.C. federal court this morning, with jury selection now underway in his criminal trial for defying a subpoena from the House January 6th committee. Bannon facing 2 counts of contempt of Congress. The committee initially called Bannon to testify last year about the lead up to the Capitol attack and also asked him to produce documents. Last week, lawmakers revealing phone records showing Bannon and then President Donald Trump spoke twice the day before January 6th. One call took place before Bannon made these comments on his podcast.
All hell is going to break loose tomorrow.
Despite being fired from his White House job in 2017, Bannon previously refused to cooperate with the committee, claiming executive privilege, the power only a president can invoke to keep information confidential. But a week before his trial, Bannon suddenly agreed to testify.
Give me a date, a time, a room number, a microphone, and a holy Bible that I can take the oath on.
The right-wing firebrand revealing this letter from former President Trump, claiming he was now waiving executive privilege, clearing Bannon to cooperate with investigators. But the Department of Justice says they've interviewed Trump's current lawyer, Justin Clark, who told them Trump never invoked executive privilege over Bannon. Prosecutors later writing, the only thing that has really changed is that Bannon is finally about to face the consequences of his decision.
How you doing, guys? Thanks for showing up.
Meanwhile, Bannon's highly anticipated trial begins the same week as the final scheduled January 6th hearing, planned for Thursday in prime time. The judge in Bannon's case is a Trump appointee, and last week he cut down a number of Bannon's planned defenses, including barring any claims that Bannon's refusal to comply with the committee's subpoena was covered by executive privilege. Jay O'Brien, ABC News, Washington.
All right, Jay, thank you for that. Our D.C. Bureau Chief Ben Kennedy will be live in Washington later on today with the very latest on Steve Bannon's trial. And a major traffic alert in downtown Fort Lauderdale. The heavily traveled Henry E. Kenny Tunnel, it is shut down.
Local 10 News reporter Trent Kelly tells us about that closure that will last all week.
This is a multi-million-dollar improvement project that has been in the works for quite some time. Not only are crews going to be working on the Henry Kinney Tunnel, but they'll also start construction on a brand new pedestrian plaza as well. But in order to start that work, they have to shut down that tunnel for at least the next week, something that's already causing a big headache for many drivers.
The detour is crazy.
It will be 1 week. 1 week. It's terrible for us.
Drivers dealing with some major traffic tie-ups today after crews temporarily shut down a heavily traveled tunnel cutting through the heart of downtown Fort Lauderdale. Is traffic already a mess?
Of course, yes. It's terrible, especially in all these places, in North Andrews, Las Olas.
Starting today and lasting through Friday, US 1 from Broward Boulevard to Southeast 7th Street will be closed completely, including the Henry E. Kinney Tunnel. It's part of a $28 million improvement project that will extend the tunnel by 20 feet, upgrade safety and communication systems, and add a new pedestrian plaza right on top of it. In addition, part of Las Olas Boulevard between Southeast 5th and 8th Avenues will also be shut down starting on Wednesday.
The good thing is that we scheduled this to come in the middle of the summer. People are on vacation, school is out.
While city officials tried to minimize the impacts, many drivers are still finding it hard to steer clear of the mess, even with extra signage and detours in place.
It's terrible for me, especially that I do Uber. All my pickups are there, so it is impossible to drive to that place. I can park.
But others are more willing to put up with the temporary inconvenience if it means improving the existing infrastructure.
I know the detours of the city, so it's not really an inconvenience for me. But people who just, drive the route every day, it's going to be a very misfortune for them.
Right. And officials estimate the road here should reopen by sometime late Friday night, but they tell us that could extend into Saturday as well if the work is running behind schedule. That's the latest from downtown Fort Lauderdale. I'm Trent Kelly, Local 10 News.
Thanks to Trent for that report, and ahead for you at noon. Bennifer makes it official.
Oh boy, details on the Las Vegas wedding for Ben Affleck and Jennifer Lopez after the couple rekindled their romance 20 years later. In your pop topics, major entertainment news over the weekend. I'm sure you've already heard that Jennifer Lopez and Ben Affleck got married in Vegas. Lopez says that they flew to Vegas, got their license, and were married just hours later at midnight. We know that her twins were there at the ceremony with her. J-Lo also revealing that she got married in a dress from an old movie, one that she's been saving for years. Her groom also donning a cream tuxedo that he happened to have just in his closet, paired with a black bow tie, apparently. The bride also writing in her wedding announcement, quote, "When love is real, the only thing that matters is marriage is one another, and the promise we make to love, care, understand, be patient, loving, and good to one another." She went on to say that love turns out to be patient, 20 years patient. The pair reunited about a year ago after famously dating in the early 2000s. It's a fourth marriage for her, the second for him. And Lizzo has dropped her fourth album. The album, called Special, is the Grammy winner's first album in 3 years. The first single, About Damn Time, hit #2 on the Billboard's Hot 100. This comes just a few days after she got an Emmy nomination for her Amazon Prime show, Watch Out for the Big Girls.
Riding high right now. Just days before one of Miami's biggest events of the year. one of its headliners is bowing out. Kanye West pulling out of Rolling Loud at the last minute. It's forced organizers to scramble to find a replacement for this Friday's headliner, which will now be Kid Cudi. They say it's the first time in the festival's history that a headliner has pulled out of a performance. West also pulled out of headlining at Coachella earlier this year. So here's a look at the new lineup. Again, Kid Cudi will replace Kanye as the headliner this Friday. Then on Saturday, the headliner will be Future. Then Kendrick Lamar will wrap up the weekend as a headliner on Sunday. Rolling Loud runs from July 22nd through the 24th.
And let's take a live look outside from our Miami tower cam right now. We've got some clouds out there. We also have some sunshine, bit of a mixed bag. We'll talk to Jordan when we come back.
Well, South Florida, we have plenty of sunshine on our beaches this afternoon. If the kiddos have off, or if you have off, you be sure to get outside and enjoy the fact that it's not raining, which we saw all weekend. We have plenty of sunshine out there. That'll be the trend for the beaches for most of the day this afternoon, getting temperatures into the low 90s. Those heat indices will be in the triple digits, though. Notice the 40% chance of showers. We are anticipating our sea breeze to develop some scattered showers and storms, mostly inland. But as we enter the evening commute, some of them might try to backbuild, maybe towards I-75, the turnpike. But then as we enter our Monday evening, we'll be on the drier side of things. As we head into Tuesday, we say goodbye to storms and hello to Saharan dust. What that means for your forecast at 3 o'clock.
Okay, we'll talk to you at 3, and that does it for right now for our noon show. We thank you so much for watching.
We'll have more coverage on the Parkland school shooter penalty phase trial when they kick back in about 20 minutes from now. We'll see you soon.
And of course, you can always get the very latest breaking news all day long at local10.com. Have a good afternoon. And now to a special report for you here. We're looking live inside the Fort Lauderdale courtroom. That's where testimony is scheduled to start soon in the penalty phase trial of the Parkland school shooter. We want to get right over right now to Local 10 news reporter Christina Vasquez, who's been following it all.
I've been inside the courtroom all day long. Christina, as we check back in, supposed to start back up at about 1:15 or so, according to the judge. So catch us up so far for anybody just tuning in as to what's happened and what we can expect moving forward.
Yes, indeed. To your immediate question, right when we come out of recess, we will see the first witness for the state's case. That's because the defense decided to reserve its right to hold its opening statement until after the state presents its entire case. Let's start with the families here, right? Family members of Parkland murder victims and the shooting survivors. You have to remember what today means for them. Today marks 4 years, 5 months, 4 days since the then 19-year-old Nikolas Cruz went to Marjorie Stoneman Douglas High School in an Uber armed with an AR-style rifle and shot and killed 17 MSD students and staff, hurt another 17. You may remember he pled guilty in October. Those guilty pleas to the murders is what set up the penalty phase. So it's an interesting position for these jurors to be in because guilt has already been established. The jurors sworn in this case, there's a 12-jury panel and 10 alternates. They're essentially walking into what is typically the second phase of a capital case, a penalty phase. So what they're tasked to do is listen to the evidence that, as we mentioned, is going to be starting right this afternoon, listen to the evidence from both sides, and they have to weigh the evidence that they hear and make a determination about whether he should be given life or death. So now we have this morning the start of all of this with opening statements, and lead prosecutor Michael Satz, remember that they are seeking a death verdict, right? They want to convince these jurors that the appropriate punishment for this crime is death. And so part of what he did in his opening statement in order to start giving an overview to the jurors of what kind of evidence to expect is really getting at some points even granular, but in that it was chilling and harrowing as he walked jurors through step by step, almost the point of view of the Parkland shooter, how he went from one hallway to the other, where all the victims by name were standing. He really stressed, for instance, the victims that were essentially shot execution style. These are ones that were already shot, wounded, maybe could have survived, but Nikolas Cruz doubled back on them and shot them. He went through the ages, how many gunshot wounds they died from. Now, the reason why he is taking all of that time to meticulously kind of present the facts of the case is one of the arguments he's going to be making throughout the state's case to these jurors is that the facts of these cases show that it was cold and calculated, that it was premeditated, that it was heinous and atrocious. Those are legal terms from Florida state statute of something called aggravating factors. It's what the state has to prove beyond a reasonable doubt. In fact, jurors have to unanimously decide that one of these aggravating factors exists before they can even have death on the table as a possible sentence in this case. So that's why from his point of view, it'd be very important for these jurors in the opening statement to deliver this, just the powerful nature of the facts themselves. Now, as this is happening, it was interesting. The jurors themselves, and the way I'm sitting in the courtroom, they're kind of right in front of me. Several of the jurors definitely began to be taking lots of notes, dutiful notes. Two stood out to me the most. One is a Broward County library worker. You could see her processing the information, especially when he was delivering some of those key details, how many shots were fired over how much period of time, she's writing that down. And the other one that was definitely a diligent note taker and seemed really engaged was one of the jurors who her job is a compliance supervisor for a medical device company. In fact, she had said during jury selection that her dad's a police chief. She was really engaged and leaned in. A lot of the other jurors, some of them sat back. There was one that at one moment, as they were going through, again, the ages of the victims, 14 years old, shot this many times. She had her hand just, over her face, just kind of taking it all in. As this is happening, of course, you have the family members, many family members of the Parkland murder victims in the courtroom, and some of them openly weeping in court. In fact, in front of me was the family of Helena Ramsey. One of her party literally had to leave the courtroom. She just had to physically walk out, as some others in that row were just trying to still be there and strong to support their loved one, but finding it very difficult to hear all of these details. You could hear them choking back and kind of trying to hold themselves together as tears are streaming down. Other folks on the other side of the courtroom, just several family members, especially when there was the father of Gina Montoya, when Satz said her name for the first time, and explains to the jurors where she was in the hallway. She had just asked a teacher if she could work on her laptop in the hallway. They explained to work on a project. When she gets shot, when he's presenting that, you see him just close his eyes and take a deep breath. Must take a lot of courage and strength to be family members of these loved ones and to be in this space. You could definitely feel the weight of the moment in the courtroom, but you have to remember a lot of these family members, and some of you probably know this already, some of the Parkland parents have become activists, right? They've been very vocal. They've spoken about the death of their loved ones in public settings quite frequently as they advocate for sensible gun control legislation, things like that. But for them now to be here, right, at the start of a process that, again, they have been waiting for more than 4 years. So it was somber, and the other word would be powerful from the lead prosecutor. So the court went into recess. In a few minutes here, we're going to start back up with the state calling its first witness of its case. And one thing to keep in mind is, as of today, these jurors really are making history. This is a very unique case in that most mass shooters of this scale, again, 17 dead, 17 hurt, never make it to trial. According to FBI statistics, most mass shooters are either killed by police or commit suicide. And so the jurors are going to be asked to do this thing, to listen to what is going to be some harrowing, grisly evidence and testimony, and then be able to be open, right? Put their personal opinions and feelings aside. That's what they were told to do during jury selection. That's what they told the court they could do, to also carefully weigh the evidence that the defense will present, which is anticipated to be about his background, his childhood, and then in deliberations eventually weigh those and make that decision of whether it's life or death. They will have to be unanimous and choosing death. And so that means for the defense in this case, really all they have to do is convince one juror that the evidence they present has a higher weight than those aggravating factors, cold, premeditated, calculating, right, heinous, and atrocious. Just one to choose life, and he would get life. Back to you.
Christina, real quickly, our hearts just break for the families having to listen to the whole timeline of this harrowing event. But what about Nikolas Cruz as he was listening to the prosecution lay out its case? What was his demeanor like in court?
It's a good question. I'm glad you asked it. One thing I noticed is he does have a face mask on, which is not atypical, right? But I have covered all of the pretrial hearings for months, like 9 months. I covered every single day of jury selection. I have never, other than today, quite seen a mask quite that large, sort of covering a lot of his face, if you guys had a chance to see the live feed. And so it was interesting to me that he was sort of, his facial expressions were a little more hidden than I've ever quite seen. And I also thought, because I kept glancing over to him at certain moments, especially certain harrowing moments of the opening statement, just kind of wondering, and could he hear, for instance, I was wondering, some of the family members kind of crying in court. And he had kind of the same demeanor he has during a lot of these moments that we've seen in the past, where he sort of looks like he's busily writing something, and then we'll kind of confer back and forth with one of the attorneys. There was only sort of one moment that I personally ever really saw him kind of sit up, look around the courtroom, and sort of take in the moment. Otherwise, he was very focused on his desk or conferring with a defense attorney.
A lot to take in, Christina, on what is the start of what will be a very long process for at least the next few months. Thank you so much. We'll check back in later on, and we certainly have more coverage to get to you on this first day of the penalty phase in the trial for the Parkland school shooter, both on air and online. For now, we're going to take a quick break. We'll be right back.
want to go back for that live look. This is the picture that we're getting out of the Fort Lauderdale courtroom, at least at this point. We're going to be back. We do have some legal analysis right now that we want to get to.
And that includes Local 10 News reporter Janine Stanwood, who is with our legal analyst David Weinstein. You guys have been anchoring our digital coverage so far this morning, getting a look inside at everything we've heard so far. What's your perspective on what we've seen?
Well, you know, what's interesting, Christina was talking about sort of the power of the state's opening statement and imagining how that impacts those families and the people who were listening in the courtroom. Even for us here in studio, it was really something to listen to.
It was, and it's heart-wrenching for the families of these victims to be hearing this. But again, the impact that it's going to have on these jurors is going to be to get them to focus on just what happened, how it took place, what the planning was that Cruz put into it. And at some point, they're going to hear his own words as Michael Satz described them the day before when he recorded that video. That is going to be a very powerful piece of information for them to take in, because that really puts the focus on just how long he was planning to do this.
And to remind our viewers, so this certainly has to be unanimous. And one juror says that they don't agree, that they don't think that all of those aggravating factors can be proven beyond a reasonable doubt. And if that is the case, then it will remain life in prison without the possibility of parole, because Cruz did plead guilty to all 17 counts. Can the judge override that?
The judge can't override a life recommendation. The only thing the judge can override is a recommendation of death, because she then, after she gets the verdict, 17 different verdicts, because there are 17 different victims, for each verdict that suggests death is the appropriate penalty, she then has to reevaluate the aggravating factors and the mitigating circumstances and either agree with the jurors that as to that victim, those were established beyond a reasonable doubt and not outweighed by the mitigating circumstances. Or if she disagrees, then she'll have to set out in an order why she feels either the state didn't establish enough aggravating factors, or if there was a mitigating factor that overrode what the state has established.
So the state wrapped up its opening testimony. We could have heard openings from the defense. They waived their right to do that, correct?
That is correct, and that's their choice. Any defendant has a choice whether or not they want to present their opening statement right after the state has presented theirs, or if they want to waive it and save it for when the state's done presenting all of their evidence. If I had to guess beforehand, I would have thought that they were going to lean that way because of the amount of time that's going to pass. I think in their mind, whatever statement they were going to make after hearing what the prosecution had established was going to get lost on these jurors. And so they've decided, you know what, we'll save our opening until after we've heard everything the state's going to put forward. That also gives them an opportunity not only to make an opening statement, but to get two cracks at a closing. Because at that point, they will then have heard all of the state's evidence. They would have seen what witnesses are being brought forward, and they can say, okay, that's what you just saw. That's why it's not enough aggravating. And by the way, here's where we're going to present to you in terms of the mitigating circumstances that you should consider when deciding what the penalty should be.
So Mike Satz, lead prosecutor, sort of took us through the moments that began at 2:19 when Nikolas Cruz arrived at Marjorie Stoneman Douglas High School. He went through that narrative, but there's also some video to go along with that narrative, so that could be something that we hear when this first witness comes up.
It probably will be. I mean, I have to think that they're going to continue to want to paint this picture for the jurors. And what's the best way to paint a picture now in today's society is with photos, with video. Is it going to be that video from the 13th of February when Cruz was saying what he was going to do? Is it going to be an opening shot showing him entering the school, entering the classroom, showing what he was going to do? Again, the point here is to make this impact on the jurors. Show them something that they're going to remember, and down the road when they're deliberating, they're going to say, wow, well, the first thing we heard from them was this. And then they proved all of that. I don't think that we're going to see any testimony from the first witness about cause of death or anything like that. That's something they'll build into their presentation as it goes along.
You want to make your biggest impact off the top.
Absolutely. It's like anything we see, watch, read. You want to make that first impact meaningful, something that sticks, something that's going to linger on the mind of these jurors as to what you've shown them about this individual who they're about to decide Should he receive a death penalty 17 different times, or is it something where these mitigating circumstances outweigh the aggravating factors, and his, as the defense will say, is a life worth saving?
And to keep in mind, the jurors will hear and see everything, but the public, i.e. the media, will not, because the judge ruled just last week that there are some videos, there's some evidence that's too gruesome and too graphic.
And that's the way it is in all cases. Look, in Florida, we operate in the open. Everything is open. If you wanted to go down to the courthouse and you could get admitted into the courtroom, you'd be able to see what was there. But at a certain point, the judge has to draw the line as to how much of this am I going to spread across the world, across the web, so that people can see things which are very graphic in nature to begin with, and then it's personal for these victims and the next of kin to have those images to be shown in a courtroom is one thing, but then for the world to see them, it's a completely another thing.
The jurors, there's going to be a lot that they're going to have to take in. And of course, some viewers were asking us, why did this take so long? We thought court started at 9 o'clock, and it did. There was a question in the very beginning about one juror, and did this potential juror, or I should say not potential juror, did this juror talk about the case, which is something you cannot do. It was somebody who brought it to the court's attention. So there was a little bit of time spent on that even before we got to the opening statement.
These things never start off without some sort of bump in the road, and we had a bump in the road right from the get-go. Someone had sent an affidavit to the prosecutor saying, I was in a doctor's office and I overheard this particular person, named by initials, who was talking about this case and about their feelings about the death penalty and their position on it, which if that person was seated as a member of the jury, they shouldn't be doing. And so the court did what it needed to do, and the prosecution did what they needed to do, which was, we need to bring this to the attention of the court. All the jurors are here. Before we swear in the panel, we need to bring in this particular juror. And the state said, this is who we believe this person was. And then the judge put that juror under oath and said, you need to tell me the truth about what this is, because if it happened, then you might not be able to serve. And the juror denied having that conversation, denied that this incident took place. So the question then becomes, why did that person send the affidavit to the prosecutor's office? Did they misunderstand something? Was it not this particular juror? Remember, there were so many members of the potential jury panel that were spoken to leading up to this. It could have been someone else who had similar initials. But the judge decided, based on the demeanor, the answers, the way this person was answering, that she was going to take this person for their word. And so the judge said, I'm not going to disqualify you, thank you. And it sort of serves as a reminder that everybody's watching, everybody's listening, and these jurors need to follow the instructions they're given by the judge.
Very strict instructions. They cannot talk among themselves during breaks. I mean, they can, but not about the case, obviously. And they're not sequestered in the sense where they're staying in a hotel. They can go home. But in this day and age of social media, they're told to turn off their phones. But so many of us with smartphones, you turn it off and you turn it back on, and you have a news alert, you have a social media alert. How hard is it going to be for these people to avoid this trial that so many people in South Florida and around the country are watching intently? And there are news articles, there are going to be things that are popping up left and right.
I think it's going to be amongst the most difficult things for these jurors to do. As you pointed out, when you turn on your phone after it's been off, all those alerts that were sitting waiting for you, whether it was the score of the Marlins game or what the traffic looked like or what tomorrow's weather, and the latest updates to news are going to come flooding into your phone. So as a juror here, how are you going to ignore those along with everything else that comes in? It's going to be really hard.
Does that become part of sort of standard juror instructions? And we didn't hear that in open court. Obviously, we were told that you should avoid all of these things, but you would think maybe in this day and age that would be part of a standard juror instructions to, I don't know, disable social media or to turn off your alerts.
I think that it might have to be.
Yeah.
I mean, at this point, she's instructed them, don't go out and do any of your own investigation. Don't look on the internet to find out about this case. Don't listen to things that people tell you. And that's usually enough to get people to focus on what's going on. But now, perhaps what we're going to need to do and tell jurors is, I need you to go into your phone, I need you to go to your settings, and I need you to disable all of your notifications so that you don't accidentally get a notification about this. And she's told them all, if somebody approaches you, if somebody talks to you, if you hear something, you need to tell me what it was that you heard, whether it's during the week, during the weekend. We'll give you a number. She's given them another number to give to their loved ones in case they need to get in touch with them because their phones are off. But it is going to be very hard for these people not to pay attention to some alert that comes in.
Just a reminder for our viewers that court was supposed to resume at 1:15. That was what the judge said just a little bit before noon. They wrapped up openings a little bit early for the state, and because the defense waived their opening, then the thinking was, okay, we'll break for lunch. We'll be back at 1:15. Right now, it's just after 1:20. That hasn't happened yet. We're looking at the seal, which is the seal in the courtroom, which basically means it's not in session yet. So we're waiting. There could be delays. I mean, there are people that they have to get into the courtroom. It's a lot of people you've got to wrangle to get back in there.
You've got to get the jurors back into the jury room to make sure everybody came back from lunch on time, that everybody's there and accounted for. The prosecution team needs to be there. The defense team needs to be there. They have to get the defendant ready and back into the courtroom. And then whoever that first witness is, that person needs to be ready. That person needs to be there. They can't be, oh, I'm parking, I'm on my way. So this has to work. And the way it's supposed to work is that the people who are least inconvenienced are the jurors. Unfortunately, there's a lot of hurry up and wait here, and so it's something they're going to just have to get used to. We'll all have to get used to that. Just because we said 1:15, it might be 1:25, it might be 1:35, but you can't start until everybody's there.
And all eyes are really on Fort Lauderdale, on the courtroom right now, and this is something that so many people have been waiting for. And of course, inconveniently, I don't know if you live in Fort Lauderdale or if you're in South Florida, and the Henry Kinney Tunnel closed for construction starting today. So that certainly isn't something that has helped the situation if you're driving around Fort Lauderdale this morning, if you're a juror trying to get there on time. So there are all sorts of human factors that go into it. We could set a clock and say, okay, 1:15, but people are people, and they run late and things happen.
Elevators get broken. You don't get where
hopefully
you're
not in the new courthouse, but right.
Well,
yeah, you never know.
Never know.
Yeah, you never know. So one more thing that we were sort of talking about. This is expected to go on for a long time. About 1,300 witnesses. We were talking about 1,000 on the state side, 300 on the defense side. I think that was the last number that we heard. But that does not mean that we're going to hear from 1,300 witnesses.
No, they don't need 1,300 witnesses to establish the 7 aggravating factors beyond and to the exclusion of a reasonable doubt. They're going to need some number between 0 and 1,000. And they're working on picking that number, but in order to make sure that the defense is aware of every potential witness, you have to list that many people. And in some ways, it's a game of chess, because the prosecution isn't necessarily going to tell you who exactly I'm going to call. The defense is going to anticipate who they're going to call. Works the same way on the other side, too. If they've listed 300 witnesses, they're not calling all 300 of those people. Prosecution has to be ready for who they're going to call. Obviously, the judge is going to, at some level, inquire of each side as they're making their presentation, okay, who's the next witness up, so that we don't have a delay, so that the defense isn't saying, well, had we known it was that particular witness, I would have had a different box of paperwork here to go through, to take a look at what our preparations were. But we're not going to hear from 1,300 people. There's some number between 0 and 1,300.
One thing that we heard, I think it was this morning, there was a motion by the defense to delay because one of their witnesses, who was, I think, an expert in fetal alcohol syndrome, might be retiring. So what does that mean?
Well, they filed a motion prior to today's court proceedings. I can't remember if it was over the weekend or just late last night, that one of their experts has decided that she needs to retire for whatever reason she needs to. There was something in the motion regarding some condition that she was suffering from. And on this particular witness, because of the narrow area of specialty that this witness is going to testify to, there are only a limited number of experts in that field. And so for them, they devoted a lot of time and energy to getting this witness ready. From what they said in their pleadings, this witness spoke specifically and directly with Cruz, reviewed certain things, and in their words, it's not like we can take everything that this expert had put together and just give it to another expert. And what they asked the court to do was not to delay today's proceedings, and quite frankly, there's no way in the world that this judge was going to stop the train from leaving the station today, but rather what they've asked is, we're asking for 45 days. Now, she may not give them 45 days, but they want a delay of 45 days from when the state rests their case until they start presenting their mitigating circumstances to get this new person on board, to allow this person to speak with the defendant, to review everything else that's been looked at by the expert, and the state's entitled to take this person's deposition, so they're going to factor that into the equation. How much time the judge gives them, I don't know, but she's going to need to give them some time. They've made it a centerpiece of their case to say that this particular factor, the fetal alcohol syndrome, is something that they're going to rely on as a mitigating circumstance.
And to sort of bring this back home to our audience, you know, the mitigating circumstances are things that I think the defense are hoping may outweigh those aggravating factors, right?
Correct.
And so mitigating circumstances could be, for example, the mental health, the mental clarity of Nikolas Cruz, his upbringing. So we mentioned fetal alcohol syndrome. His biological mother had addiction issues, and then he was adopted. So those are the types of things, perhaps, that the defense could bring forward.
Well, it's going to be one of the factors that they have very little to work with here in this particular case, some of which was already fronted by the prosecution in their opening statements, and some of which is going to be difficult to combat when you're talking about somebody's mental condition and their mental state of mind. We've already heard the prosecution talk about the fact that they're going to introduce or will be introducing statements he made beforehand, recorded statements, the methods that he used to prepare to go in there, the methodical way he went through each of the classrooms, the number of magazines he had. Are these things that the defense is going to argue were not something that someone of a limited mental capacity could develop? The prosecution is going to say you shouldn't give any weight to any of that, but perhaps one of the things that they're going to focus on are going to be his age at the time he committed the crime, and then his biological mother's addiction and how that affected his ability to develop and how his brain developed. And so if the judge gives the defense no time to prepare this new expert and guts their defense, that is going to be the number one issue on appeal if, in fact, there's a death sentence that's imposed and one that goes up on automatic appeal to the Florida Supreme Court and from there up potentially to the U.S. Supreme Court.
Well, we'll continue to watch. Of course, today is just day one, and we heard opening statements, the opening statement from the state. We are waiting to see who they present as their first witness. Court was supposed to resume at 1:15. There's been a little bit of a delay. Don't worry, we've got you covered every step of the way. We'll be watching, and we'll be back as soon as court comes back. I'm Janine Stanwood, and this is the sentencing of Nikolas Cruz, confessed Parkland shooter. We are here with our legal expert, David Weinstein, attorney, former federal and state prosecutor. So glad to have your expertise. Court was supposed to resume at 1:15. There's been a little bit of a delay. What could possibly be happening right now?
Well, welcome to my world, Janine. We go through this all the time. It could simply be somebody didn't get back from lunch on time. It could be that the state's first witness wasn't there where they thought they were. It could be a technical issue regarding what the evidence is that they're going to be introducing. Perhaps there are audio or video or photographs that they want to exhibit to the jurors, so they need to make sure the courtroom technology is working. Maybe they didn't get the defendant out from the back in time. I doubt that it's a freshly filed motion on behalf of either the state or the prosecution, so it's probably just a logistical issue about having everybody in and everybody in order, and we might be getting back to live action.
We might be. Yeah, we see the camera shaking a little bit and talking about sort of the logistical issues if there is some evidence that they want to show to the jury in open court. Some of it, it was ruled, if it's too graphic, will not be shown to the public, i.e. the media, so we would potentially just be seeing sort of a blank screen or the camera would go up. So that's something for our viewers to keep in mind as we continue to watch. So you can see the camera is trained right now sort of on that door. So we will see, you know, if the judge enters and the defendant, and hopefully, you know, that happens soon. But today, this morning, we heard openings from Mike Satz, lead prosecutor, and they were the remarks were methodical. They were extremely detailed. Names, ages of not only the victims who were killed, but those who were injured as well. And even though the testimony, the statement from Satz was very matter of fact, it was so powerful because of the detail, and you could see the families sitting in that courtroom. Some were crying.
There were a lot of people who were crying, and I think a lot of us who were watching it got very emotional about what we're hearing. I mean, keep in mind that these next of kin are hearing this story again. They've heard it before, perhaps they've even seen some of the images, but now they're hearing it again, and they're hearing it in a room where they're sitting with the person who's admitted that he committed the crimes, and that impact has to be felt by all of them. And the same methodical method that Mr. Satz presented his case, going through the names, going through everything, he's going to do the same thing to show that was the same methodical method that was used by Cruz and the planning. You heard him refer to timestamps and videos that were taken. You heard him talk about the number of bullets and why the particular weapon was chosen and why he was firing through windows to get to people, warnings he gave to other people that was on the way. And again, he's establishing a premeditated plan on the part of the defendant, one of the aggravating factors, and they're going to harp on that again and again and again for these jurors.
And he was saying that there was really no way that any mitigating factors could outweigh that. That was the point of those opening statements. Well, we thought maybe something was going to happen, but maybe not. We're still waiting. But I think that's exactly right. I think his cadence and his delivery and those remarks mirrored what he said happened that day. And so not only are the families watching, but the world is watching these opening statements. And it was really powerful. It was really powerful to not only see these family members in the courtroom listening to this, but you have to think that they know that everyone is watching it too.
And the jurors are watching it. And I think one of the interesting observations that we heard from Christina, who's inside the courtroom, is that traditionally, if you're an alternate, you know you're an alternate because of when you were selected in the process, where you're seated in the jury box. You know that it's either 6 or in this case 12 jurors, so that means everybody after 12 is an alternate, but not the case here.
Right, she said they were seated alphabetically.
Alphabetically. So the prosecution and the defense knows who the prime members of the panel are, who those 12 people are. We know simply by the people who've been watching it, but those 22 people who are sitting in the jury box, they don't know. And so what that does is that forces everyone in that box to pay attention to the same degree. We're all human beings, and if we're told we're just an alternate, well, you know what, perhaps we're not going to pay as much attention as somebody would who's a member of the main panel. Well, now all 22 of those people really don't know who is the primary juror or if they're an alternate here. So I think that that will cause all of them to take good notes, to pay attention to what's going on, and to listen a little bit harder than if they knew that I'm number, 18. There's no way that I'm going to be a part of this jury. I'm here, I'll pay attention, but not as much as somebody else.
They can't have their phones. The phones have to be turned off, but they were all given a pad of paper and pen. And Christina had said that at one point, as Mike Satz started making his opening statement, narrating the path of Nikolas Cruz. Many of them, she said, started, fast and furiously writing down notes.
And that's a good thing and a bad thing. So it's a good thing because if you're someone who needs to take notes about what you heard or what you saw, you're going to take notes. And if you're taking notes, that shows you're paying attention. But the bad thing, and you heard the judge talk about it, your notes are not evidence. Number one, nobody's going to see them but you. We're not sharing them with anybody. And number two, going back, and we'll hear this again and again, you have to rely on your own recollection of what the evidence and the testimony was. And so what will happen down the road is, despite that, there will be an issue of contention in the jury room, and one juror will say, oh, I took this particular note, and this is how I remember it, and see, that's what my notes were. Another juror will say, well, no, that's not how I heard it. I have a note that reflects something different. So that's either going to make the process a lot longer, or at some point, two or more people are going to have the same written recollection, and despite the fact that they're told not to rely on those, that'll be what settles the argument.
And we've gone through this before, but I think it is worth mentioning again. This jury has to be unanimous, and it's not just one count of murder. This is 17. He pleaded guilty to 17 counts of first-degree murder and 17 counts of attempted murder. That means automatic life in prison without the possibility of parole under Florida law. But they can decide based on the aggravating factors that he deserves death.
Right.
And they have to be unanimous.
They have to be unanimous, and they have to be unanimous as to 17 different verdict forms. They're not going to get one form that says aggravating factors outweigh mitigating circumstances as to every one of these 17 people. They're going to get 17 different forms. And so to some degree, it is going to be difficult and painful, and we're going to see that through the presentation of the evidence. The state's going to introduce 17 individual different instances to some degree of what the aggravating and mitigating circumstances would be.
Meaning, for example, a medical examiner talking about the manner of death of one victim versus another?
Correct. As to how this particular victim suffered, how their death was prolonged, how another individual may have been shot a certain number of times, and that the fatal shot was not the first or the second, but rather the fourth, and that the defendant continued to shoot at that particular individual.
It was excruciating enough listening to Mike Satz talk about it. I can't imagine anybody in this audience having to listen to the medical examiner. And this is just purely from an emotional point of view, not from the point of view of somebody who's a juror and has to listen to the facts of the case, but I just can't imagine being in that courtroom.
And to some degree, that's going to play into the defense's strategy as to how much cross-examination they're going to engage in with a particular witness, whether or not after the prosecution establishes what the cause of death was, whether they'll stipulate at that point based on the evidence they've heard. They're not going to just stipulate as to cause of death, and they might try. I don't know that the prosecution is going to accept it, because part of the presentation is to show just what the aggravating factor was in a particular victim's death. So to a certain degree, they may concede certain things to sort of lessen the impact of what the jurors are hearing.
We're just seeing some video of Tony Montalto and Fred Guttenberg, listening to Mike Satz, who's right there on the screen, who's giving his opening statement, and it was just such a hard time for these family members. At one time, a family member actually had to leave the courtroom, and there may be more of that as this goes on. This is not going to be easy, and as Christina had mentioned, this is really unprecedented. I mean, this is really the first time a school shooter who's killed so many people has made it to trial. And so here we are, and we're watching this, and we're watching Nikolas Cruz, who for the most part kept his head down. At one point, it almost looked like he sort of purposefully turned his head away from the families during openings. I think for these family members to be, as you mentioned, in the same room, it's one thing to see him in video. It's another thing to see him through in a video in a jail cell, but to be in a room and seeing the person who confessed to killing your child, that's something else.
It's just got to be unfathomable what they're going through here. But that's the way this process works, and that's why a defendant has to be present during all critical stages of the proceedings. That's why victims have rights. Certainly not only under the U.S. Constitution, but under Florida's Constitution. You have a right to be present. You have a right to have and for next of kins, to have your voice heard, to be advised of what's going on. And as difficult as it is, it gives them some sort of finality to what's going on here, and to be able to see the person who's done that. It's hard. It's just heartbreaking to see what's going on, but that's what the process is here for.
Correct. And we may hear from some of the victims' families. We don't know. I had spoken to one Parkland parent asking, will you speak? Will you give an impact statement? And his answer was, I will do what I have to do for my daughter. And so we may be hearing from them, and I imagine we will.
If we do, we'll hear from them after the state's presented all of their aggravating factors. What the law allows is for next of kin of the victims to give a victim impact statement after the state's proven a certain aggravating factor, if enough, or if one exists. And then at that point, they'll talk about what this has done, what the impact is not only on them, but on our community to have lost these people at a young age as far as the students go, at an older age, but as someone who was part of the school community, as with the adult victims, the coach, the teacher, and how that has deprived the community of the lives of these people, and that is something that the jurors will consider.
And again, for our audience, we're considering aggravating and mitigating factors. This is not guilt or innocence. He's already pleaded guilty, and so some aggravated factors include the murder being cold, calculated, premeditated, which is one of the things that Mike Satz set out to describe in his openings. And then there's some statutory things, right? It was done to disrupt a function. One of the victims, at least one, was a public official, i.e.
a teacher,
coach.
Resource officer, the coach. The fact that there was a burglary that was committed, I mean, outside of the courtroom, people don't think that the fact that he went unauthorized onto school property to commit murder as a burglary, but it was a burglary, so that's going to factor in there as well. His prior conviction, not only for the victims who died for the attempted murders that he's pled guilty to, but also that other conviction he has for the assault on the corrections officer. Those are sort of factors outside of the case itself that they'll be considering.
Well, we're continuing to watch. Once again, we did understand that court was going to resume at 1:15. It's now 1:43. That hasn't happened. We've seen a little bit of movement here. There's a camera trained on that door, so we're waiting to see what happened. As you mentioned, David, it might be just sort of a logistical, waiting for people to show up, waiting for the technology to make sure that if there is some gruesome evidence that's shown, it's shown to the jury and not to the public. You'd think that those things would have been worked out, and I think they were, but
things happen.
Things
I mean,
happen.
The door that they're focused on now is the one that the defendant comes out of, so
Right.
it might simply be that they're just not ready to have the defendant in the courtroom yet, and he needs to be in the courtroom before the jurors come in.
And there he is.
There he is.
You can see he's walking in. One thing that Christina mentioned was sort of the size of the mask that he is wearing, that it covered so much of his face, so really not a whole lot that you could see. But now he's finally entering, and as you had mentioned, those curtains underneath the desk on both sides, and you were saying, David, that that's likely to sort of cover up the fact that he is shackled.
Right.
Probably.
I mean, that's one of the conditions that they're allowing him to be there. They've removed his hand shackles, but he's certainly in all likelihood shackled at the ankles, and they don't want the jurors to see that because the defense will argue that that's going to show unduly that he's dangerous, that somehow or another that's going to factor into their determination, not of guilt or innocence, but rather of, is it an aggravating factor, given the fact that he's wearing these leg irons.
And by the way, I do want to introduce our viewers who are watching online right now, this is the sentencing of Nikolas Cruz. This was supposed to begin at 1:15. There is a delay right now, so for our online audience, we do want to thank you for joining us. I'm Janine Stanwood with our legal analyst, David Weinstein, attorney, former federal and state prosecutor, and so far this morning, you've just been such a wealth of knowledge for us, so we really do appreciate it. Janine. Well, we've been watching the beginning of this, day one. The state made its opening statement earlier this morning. Court was set to resume at 9 o'clock. Things got started a little bit later. There was a question about a juror, but that's since been settled. Mike Satz, the lead prosecutor, giving his very powerful and detailed opening statement. And now we are waiting for the first witnesses to be called by the state because the defense waived their right to give their opening statement after the state.
And that's their choice, and they're entitled to do that. They feel that the impact is going to be greater to wait until after the state's presented all of their evidence before they make their opening statement to the jurors, and they're entitled to do that. And they've decided to do that after consulting, obviously, with their client, and he's agreed that that was a good tactic on their part. And so now we're just waiting to see who the first witness the state is going to call once they get the jury into the courtroom.
And we continue to watch this. If you're watching at home, if you're watching online, you can see the split screen right now. We do know that Nikolas Cruz, the defendant, is here. So is the judge. Do we know about the jury? Has the jury entered yet?
I haven't seen anybody stand up after they brought the defendant in, so I would have to say that they have not brought the jurors back into the courtroom yet. That's potentially what seems to be what we're waiting for here. The bailiff will announce that they're entering the courtroom. Everybody will stand. They'll be placed into the jury box, and then we'll get underway.
And the jurors have been given very strict instructions. Phones have to be off. They are allowed to take notes. One of the things that you and I were talking about was just how tough it is in this day and age. Okay, it's one thing not to talk to other people about this case.
Right.
It's another thing to turn on your phone and you've got, 5 or 10 alerts from social media or online about this case, and you have to make it a point to ignore it.
Right.
You can't. Those are the instructions that you've been given.
And hopefully these people will be able to ignore it. They'll go into their settings and silence those that pertain to breaking news or to this particular story. They'll get their weather alerts, they'll get their text messages, they'll find out what's going on around them. But as far as the trial goes, they need to silence their notifications and just pay attention to what they're hearing in the courtroom. And certainly the defense is going to be on top of that. Anybody who's caught tweeting out something about what's going on, or we already saw an example of it this morning, somebody who thought they overheard somebody saying something. I think we're getting the jury.
Yep, you can see everybody is rising. We think that the jury is coming in. For our viewers at home, so you know, as soon as we hear audio in the courtroom, you will not miss a second. We will bring it to you live. I don't believe yet we have audio in the courtroom, but as soon as we do, we will definitely bring that to you in full. But again, you can see right now, everybody is standing up. Likely the jury is walking in. One thing that Christina had mentioned as well, and we were talking about this, was so often you do know who the alternates are. In this case, everybody is seated in the box, as she had mentioned, alphabetically.
Right.
So I think there's audio. Here we go. Let's listen.
The state has presented its opening statement. The defense has reserved their opening statement. So, state, you can go ahead and call your first witness.
Thank you, Your Honor. Brittany Sinich.
Good afternoon. You can be seated. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You can go ahead and put your hand down. And if you wouldn't mind scooting out. Please state your full name for the record and spell your last name.
Brittany Sinich, spelled Sinitch.
Okay. And Miss Sinich, what do you do for a living?
I'm a teacher.
And okay. And how long have you been a teacher?
I started in 2017.
Okay, 2017. And where did you start teaching in 2017?
At Marjorie Stoneman Douglas.
Okay. Are you familiar with Marjorie Stoneman Douglas?
Yes, I was a student there.
Okay.
And then I went on to become a teacher there after college.
Okay. And I'd like to call your attention to February the 14th, Wednesday, February the 14th, 2018. Were you working on that date?
Yes.
Okay. So, Marjorie Stoneman Douglas, where do you work? Where were you teaching on Wednesday, February the 14th?
My classroom was on the first floor of the 1200 building in room 1218.
Okay. Let me show you State's Exhibit Mark A for identification. Okay. And ask you if you can identify this photograph.
Yes.
Okay. Does that truly and accurately depict what it shows?
Yes.
As an aerial?
Yes.
And does it truly and accurately depict how Marjorie Stoneman Douglas campus looked on February the 14th, 2018?
Yes, it does.
Your Honor, at this time I'd like to offer State's Exhibit A, please.
Is there any objection?
No, ma'am.
State's Exhibit A for identification will be received as State's Exhibit 1.
Okay. People are amazed that I can work this. All right. Ian, everybody can see that now? Okay. Can you see that, Ms. Sinich?
Yes.
Okay. There's a way you can mark. Do you know how to do that?
Mm-hmm.
Okay. All right. So let me clear the screen. So would you mark where the 1200 building is? Okay. And do you know where the east pedestrian gate is?
Yes. It should be here.
Okay. All right. And that's the way it exists.
Mr. Satch, one moment. Are the monitors? It's my understanding there's some privacy screens on the monitors and the jurors are not able to see what you're showing them completely.
They're supposed to. Who's preventing it?
The screens, the privacy screens themselves. I don't know what that is, but raise your hand if you're having difficulty seeing what is being presented, an aerial photograph. So
How about that? The defense is not saying it either.
We can see the exhibit, but I did not see any markings on the exhibit.
Is everyone supposed to be able to see that?
Yeah.
Well, it's not working. So,
No, I believe you.
and on my screen, I'm not seeing that either.
Where's the where it says document? Maybe we can excuse
Sure.
the jury.
Okay, ladies and gentlemen, this is a brand new courtroom, has brand new technology. I think I've explained that to you a little bit in jury selection. I apologize for the inconvenience, but we're going to have you go back to the jury room while we try to figure out exactly what's going on. But it's definitely important that everyone can see what's being presented. So please step back with the bailiff. Please do not discuss the case. Leave your notepads on your seats, please. Thank you.
Welcome back. We initially were hearing from Brittany Sinich. She was the first witness that the state had called, a Marjorie Stoneman Douglas High teacher, a former student. They presented her with a picture of her classroom and the area around it in the 1200 building. The issue is they want everybody in the jury to see it and everybody in the courtroom to see it, but technology, and not everybody could.
Sometimes technology is our friend, sometimes the old-fashioned way works better. And it would appear that they're having two different problems here. One, some of the jurors can't see the exhibit that's being put up on the projector. And second, they're asking the witness to mark on their certain locations, and the location marking isn't showing up. Before we had all this technology, you would have had a big blow up next to the witness, and they would have picked up
on
a
an
marker,
easel, right?
And they would have circled something, and they would have marked something, and that's the way it would have proceeded. So,
and this is a brand new courthouse. This whole area has been, sort of retrofitted not retrofitted, but fitted just for this. There's a media area. There's an area right now, for this particular trial, and it appears there's a problem. Is there audio now coming from the courtroom or not yet? Let's listen.
Mm-hmm.
Oh, okay. No, we did not. Oh, this is embarrassing. I'm just saying.
It appeared on that big screen up there. It did? Yeah, well, it's supposed to.
I know.
Yeah.
I just wanted you to know it did work up there.
Yeah.
And keep in mind that the technology doesn't belong to the state. It belongs to the courthouse. And so whoever's needing to fix it is somebody in the courtroom who needs to come in and fix whatever's going on.
And this has got to be frustrating for both sides. And imagine the first witness who was called. She was already very emotional, Brittany Sinich, who was right there in the 1200 building when this happened. I believe that the state wanted to show and establish where she was at the time in relation to where the defendant was coming in that afternoon.
Not only that, but they also want to set the scene. You heard Mr. Satz describe the different buildings and the floors and what was going on in this particular building. And so now he wants to give these jurors an actual look at what this looked like. Picture tells 1,000 words, so now they're going to show them where this classroom was, what the building looked like, what this particular area was. And that's why they're asking the witness to circle somewhere on there, show us where it was that you were standing. Now then they're going to go, well, where did he enter? What did you see when he first came in? And so this was their initial opening to give these jurors an idea of, for those of you who haven't been there, and if you're a juror in the panel, you weren't there, what this classroom looks like, what the building looks like, and to allow it to be more than just what you picture in your mind, but to put pictures to it.
Right, and so right now you can see that some members of the defense team and the state, they have their own screens, and when you do see a wide shot of the courtroom, there are monitors in there, so that would be for the entire court to see. And you were saying, David, you believe that the jurors each have their own monitors as well.
In most of our modern courtrooms today, each juror has a monitor that's sitting in front of them, so whatever exhibit is published, they can see it by just looking down at it. Sometimes two jurors have to share it, and if there's a privacy screen, as those of us who work with computers all the time know, if you're sitting at the wrong angle, you can't see what's up there.
If you're watching at home, by the way, we're going to go to General Hospital, but please keep it with us on local10.com online.
I have no idea what they're...
Okay, so for those of you who are watching at home on television, you know that we've gone to regularly scheduled broadcasting, but if you continue to join us online right now on Facebook or on local10.com, we continue to monitor what's happening in the courtroom as the first witness has been called, but there are some technical issues. I think there is some audio from the court, so let's take a listen.
Yes, thank you.
Turn back on.
Thank you, Ian.
Check to see that you can see it. You see the markings now? Can you see?
You know what, media, we're in recess while this is going on, please.
Okay, it sounds like that they just turned off the audio here in the courtroom as they figure out what's going on. So we believe that they are now in recess as they continue to figure out these technical issues, wanting everybody to be able to have access to some of the images from inside the 1200 building. Yeah, and that continues to happen. I don't think, correct? There's no more audio anymore from the courtroom? Right, so there's no audio anymore, so
now it looks like they're trying to develop a workaround if we switch one of the monitors that's up above until we get this, because for them to sort of put a halt to the proceedings while you get the technology fixed is going to just simply make this drag out even longer than it's already dragged out. They didn't start at 1:15, we're already at 2 o'clock. We've had about 4 minutes of actual testimony coming forward, and the longer the delay is, the longer this is going to take. They have other matters that are scheduled a couple of weeks out, and so I think they're trying to figure out how can we do this with what's working versus what's not working, and then after everybody's out, we'll figure out how to get everything else to work, but we need to move things along.
Well, and not to mention the state's opening statement began late as well. You know, this is just what happens. You have experience, and you know these things happen all the time.
You have to roll with the punches and what comes your way, and you know, just sort of grin and bear it. The important thing here is for the judge to make sure that the jurors understand that this is not the state's fault, it's not the defense's fault. If the fault falls anywhere, it's with the technology in the courtroom, and that's a responsibility of the court. We don't want the jurors to think that one side or the other is doing something to unduly drag things out or to make this take any longer than it should. And it looks like we're in for a bit more of a delay since they went to the seal again. But this happens all the time. The more we try to improve on what we're showing jurors and how we're getting the message across to them, sometimes it just doesn't work. And so now they'll fix it and they'll get back to it. And look, they've discovered this on day 1, so it'll be much better on day 2 and on day 3 and on day 4. And if technology fails, then they'll do it the old-fashioned way. They'll get a blow-up.
Right, get a blow-up, put it on an easel, and mark it with a marker.
Right.
We've been watching this since this morning. We've expected this trial, the sentencing phase of the trial, to go for some time, but as we've mentioned, all of the witnesses that have been named certainly will not be all called. And by looking at sort of the last few weeks and sort of the judge wanting to move things forward, you know, the hope is that maybe there is some sort of workaround instead of having to reboot everything, if you will, in the courtroom, because as you were mentioning, that can take some time, and that really pushes things back too much.
And they'd like to get through this first witness because they have to introduce their certain exhibits they want to get in, and we saw a little bit of that before. They showed her the exhibit, she recognized it, she authenticated it, they admitted it, and now they're publishing it to the jury. Who knows how many more of these exhibits that we're going to see through this particular witness. And if she's got a dozen exhibits to get through, then they need to get through those dozen exhibits before they move forward. And then when she's done testifying as to whatever she's going to testify about connected to these exhibits, defense is entitled to cross-examination. And so this is part of the process.
An interesting first witness to be called. I think this is, we didn't know. You don't know until it happens. So you don't know, is it going to be a medical examiner or is it, but the first witness they called, this MSD teacher, Brittany Sinich, who also said that she was a student and a teacher who was working that day.
And a lot of thought goes on as to who you are going to use as a witness to present this evidence. She's not the only person who could have testified about what this particular photo or sketch or drawing was, but they chose her for a number of reasons. Number one, she was a former MSD student. Number two, she was currently a teacher at the time, so that satisfied the requirement. Are you familiar with how it looked at the time? But again, she's a younger teacher. She's a teacher who was a student, so they chose her because that gives them an additional aspect of what her testimony is going to be. There is a purpose and a reason behind every one of the witnesses that they call, behind each exhibit that they're going to introduce and how they introduce it, and the method that they use to establish whatever it is they're going to establish with each witness. And again, it seems to me that what they're doing now is they are setting the stage for this is what the school looked like. This is the classroom setup. This is how this particular building looked. This is where entry points were made. And we will see a number of other witnesses use this same exhibit again now that it's been admitted, because they're going to talk about this with people from Broward Sheriff's Office that collected evidence once they were there. They're going to talk about this potentially with medical examiners where the bodies were found. They're going to talk about this with victims who survived, what they saw, where they were standing. And so they need to make sure that the technology works and so that they've established what this looks like and so that the jurors can see what's going on. It paints the picture of the story that they're trying to tell.
I think what we're going to do right now as we continue to sort of watch the courtroom and see what happens when they'll finally come back, we're going to take a quick break. For those of you who are watching online, don't worry, you're not going to miss a second. We are going to be watching it, and hopefully when we come back, we will see teacher Brittany Sinich. The technology issues will be resolved, and we will finally hear from our first witness from the state in this sentencing of Nikolas Cruz. We will be back. I'm Janine Stanwood, and this is the sentencing of Nikolas Cruz. Joining me is David Weinstein, our legal expert, former federal and state prosecutor. We've been watching this. The first witness was about to go on, then there was a technical issue. Looks like maybe we're back.
You can see sort of adjusting yourself so that you can have a clear view of what's being shown, and then we will, once you go home, we will work on fixing this problem. Who was it that was not able to see? Would you raise your hands again so that I can?
It's been rectified since.
It's fine now. Oh, okay, great. All right, thank you so much. Mr. Sachs, whenever you're ready.
Yeah, thank you, Your Honor.
Sure.
Ms. Sinich, I'm sorry. Would you be good enough to circle the 1200 building again for us?
It's not on the screen, right?
Wait.
Okay. I just need the tool as well, the pen.
You can press one of the color. You don't.
It's not on the bottom right now.
Ian. Wait a minute. There you go. How about that?
No.
No?
Mm-mm. Mm-mm. Oh, there it is. Do you see that? I don't know if I did that before, but
It's Ian, it's not shown on my screen to erase it either.
Press.
It's not, I mean, I see all the circles, but the things to annotate are not on here. Anyway, I'll suffer through it. Does everybody can see it, what you circled? No?
I need the pen feature.
Is that the picture?
Okay. Okay. That's what keeps loading when you put it back up.
Oh, yeah.
Okay, so let's erase all this and start again. Okay. Were you able to see that?
Yeah. Okay, everybody sees it? Okay, that's the 1200 building, and the smaller circle is what?
The pedestrian gate.
East pedestrian gate. Okay. All right, let me show you now. State's Exhibit H. Let's see if you can identify that in the signage.
Yes.
Okay, does that accurately, truthfully depict a map area of Marjorie Stoneman Douglas?
Yes.
Okay. Your Honor, I'd like to offer State's Exhibit H.
Is there any objection?
No, ma'am.
State's Exhibit H for identification will be received as State's Exhibit 2.
And State's Exhibit 2, Ms. Sinich? Can you see that?
Yes.
Okay. And the red block that says 12, is that the 1200 building?
Yes.
And to the right of that, is that Pine Island Road?
Yes.
And to the top of that, Homburg Road?
Yes.
Okay. And that's the way the outline of Marjorie Stoneman Douglas was in February the 14th, 2018?
Yes.
Okay. And lastly, let me show you State's Exhibit marked B for identification. And ask you if you can identify this.
Mm-hmm.
Now, this diagram, I know it's not to perfect scale or anything, but does that show about how many classrooms and the numbers of the classrooms the way existed?
Yes.
On February the 14th, 2018?
Yes.
Okay, Your Honor, I'd like to offer State's Exhibit B.
Is there any objection?
No, ma'am.
State's B for identification will be received as State's Exhibit 3.
Okay, Ms. Sinich. And where was your classroom?
Room 1218.
Okay.
Here.
So there's 6 classrooms on your side of the hall, right? That's the south side, is that right?
Yes.
And 4 classrooms across from you, correct?
Yes.
And that'd be the north side.
Mm-hmm.
Okay. So let's go to the 4th period. Do you remember the 4th period on February the 14th, 2018?
Yes.
Please tell us what you remember happening.
It was 4th period, which for us was the end of the day because we do block schedule. And it was Valentine's Day, so we were writing Valentine's Day cards. We were reading Romeo and Juliet, so they were pretending to write cards to each other as if they were characters. And we were having so much fun until I heard what I described as just the loudest noise you could possibly imagine, going directly into my hallway. And when that happened, everything was just happening very quick in my classroom. A student made sure the door was shut. We shut the lights off. My students went into corners. I had some with me behind my desk. Almost instantly, I called 911 just out of instinct. They couldn't hear me over the sound of the gunshots. It was so incredibly loud. And that was it. We just hid under my desk, we hid in the corners, and we tried to stay as quiet as possible until what I heard was like a walkie-talkie type of sound. And to me, that's what a police sounds like. So I peeked over my desk and I saw them in uniform, and they signaled us to wait until it was time to leave. And that's when they signaled us out, and we made an immediate right out of my building.
Okay. Did any shots come into your classroom?
No.
Was anyone shot in your classroom?
No.
So these loud bang, how many bangs do you think you heard?
It just wouldn't stop. I don't have an absolute correct number or an accurate number that I could count. It just kept going and going and going.
Did all these bangs have the same degree of loudness, or did they dissipate or appear anywhere else in the building?
They were incredibly loud. The ones that were outside of my classroom, it's like you could just feel it within your body, like all throughout your chest. When he was upstairs, you could tell they were faded, but they were just as loud, where you still knew they were gunshots happening throughout the building.
Okay. And how long did you wait before you heard the walkie-talkie and the police said, "Hold on, we'll get you"?
I don't have an accurate remembrance of time. It felt like a long time being there with my students under there. I don't remember what time it was.
Okay. And when you left, how did you leave?
We exited directly right of my classroom, which was there's an entrance exit door there.
The east entrance toward Pine Island? Okay. And you made a 911 call?
I did.
And what time did you make that 911 call?
So when I heard the first gunshot, it was probably seconds or maybe even a minute after, around 2:22.
Okay. And have you heard that 911 call since then?
Mm-hmm. Yeah.
Let me show you State's Exhibit Mark C for identification. And ask you if you can identify this little drive here.
Yeah.
Okay, and you've heard this disc?
Mm-hmm. Is that a yes? Yes.
Yes. You guys know what this is? 911 call?
Yes.
Yeah, any objection? Okay. When offer State's Exhibit C, please, Your Honor.
Okay, without objection, State's Exhibit C for identification will be received as State's Exhibit 4.
And I'd like to play it.
Okay.
at Stoneman Douglas High School, and I think there's a shooter.
Hello? You still there? Talk to me, please.
And those were the bangs that you heard in the beginning of the call, right?
Yes.
Okay. Thank you, Ms. Sinich.
Thank you.
Your Honor, I have no further questions.
Any questions?
No, thank you.
Okay, no questions?
No, ma'am.
Okay.
Danielle Gilbert, please.
Thank you, Mr. Excused. Good afternoon. You can go ahead and be seated. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Thank you. You can put your hand down. Please state your full name and spell your last name for the record.
Danielle Gilbert, Gilbert.
State you may inquire.
Ms. Gilbert, good afternoon. What do you do for a living? Or what?
Oh, I'm a student right now. I go to UCI.
Okay, all right. Normally, I would start out by asking your age, but you're out of school now, so I don't want to get anywhere near there. So you're in school, right?
Yes.
Where do you go to school?
University of Central Florida in Orlando.
Okay, what year are you in?
I'm going to be a senior this fall.
Okay, I'd like to call your attention to February the 14th, 2018. Do you remember, were you in school then?
Yes.
And where were you in school?
I was at Marjorie Stoneman Douglas High School.
Okay, and on February the 14th, 2018, what year were you in?
I was a junior.
Okay. I'd like to call your attention to that day, that Wednesday. Do you remember your fourth period?
Yes.
Okay. What time does school start then, on that day?
7:40 a.m.
Okay. And the last class ends at what time?
2:40.
Okay. So your fourth period was what?
AP Psychology.
And who was your teacher?
Miss Rayoven.
And what classroom were you in?
1213.
Okay. So during fourth period, would you please tell us what happened?
Yeah. So at the beginning of fourth period, when it just started, we were in the middle of a lecture, as per usual, and we were all seated in our desks listening to Miss Rayoven give her lecture in the front of the classroom. And in the middle of her lecture, we heard the first couple of shots. And from there, we dropped to the ground and started running towards the window. However, our teacher realized that by the window was right in view of where the window was in the door. And so she had realized that and told us to come behind her desk where we were out of sight of the window.
What kind of window was that?
It was a small rectangular window in the door.
Okay. And so what do you do?
And so once she tells us to go ahead over to her side of the desk where we're out of sight, we immediately turn around and all 31, 32 of us go over to that side of the classroom.
Okay. And then what time does class start, the fourth period? 90-minute class?
It's an hour and a half class.
Hour and a half, so like 1:10?
Sounds about right. I don't remember exactly.
Okay. But you know it ends at 2:40?
Yes.
Okay. So tell us what happens after you go near Miss Rayoven's desk.
So then we go over to the other side of the classroom by her desk, And at this time, he still hadn't shot into our classroom at that point. We were just sitting, kind of like sitting ducks. We had no way to protect ourselves, no way to stand up for ourselves. And once we were all kind of over by the door and away from the door, that's when he had shot into our classroom. He injured 4 people in my classroom, one of them being fatal. And from there, we just kind of sat and waited until the police came and took us out of the classroom.
Okay, and who did you see that was injured?
Benjamin Wikander, Samantha Mayer, Madeline Wilford, and Carmen Shenchup had passed away.
Okay, and were you near any of them?
Not in particular. They were more towards the podium and by the whiteboard, and I was more towards the door.
Okay, and did you do anything to record what was occurring?
Yes. I'm not exactly sure why, but my initial instinct was to pick up my phone and start recording. And so I did. I took several videos of what was happening. Yeah.
Okay. And did you retain those recordings?
Yes.
And did you turn them over to the authorities?
Yes.
Okay. And have you viewed those videotapes since?
Yes.
Okay. Let me show you State's Exhibit Mark D for identification and ask you to take a look at this drive, Ms. Gilbert, and see if you can identify her.
Yeah.
And are your 7 videos contained on there?
Yes, they are.
And did you initial this to
I did.
say it was the same, one and the same?
Yes.
Your Honor, this time I'd like to offer State's Exhibit D.
Is there any objection?
Yes, Judge, we have a sidebar.
Sure.
Okay, so this is witness number 2. This is Danielle Gilbert, a UCF student. She was a junior at MSD. She took videos when this happened. What's happening right now? People are putting their headphones back on.
Either only the people in the courtroom are going to hear what was on this, or there's some discussion being had amongst the lawyers as to how they're going to go about publishing this. There are going to be graphic images here, so this may be the first example of how the judge is going to control what is seen inside but not outside of the courtroom. They're having some discussion, it would appear at this point, or they're playing some of the audio off of it to sort of float it through the lawyers first as to what's going to happen.
Now, we know, based on the ruling last week, that the public, the media, won't be able to see everything because some things are too graphic or gruesome. Were some images, some videos, were they already flagged as being that way, or are these decisions being made as these witnesses come into the stand?
I would think that it's going to make things move a lot quicker if they pre-flagged what videos. And I think there was a discussion in one of the preliminary hearings about which videos, which photographs were going to be submitted and then allowed to be viewed. I know some of the argument was, with medical examiner testimony, do you really have to even show that to the jurors? So I think that they know what some of these images are and who's going to be able to see them. So to that extent, that may be part of the discussion they're having now. Or, in fact, what they're doing is they're showing it to the people in the courtroom, but the fact that only the attorneys and a judge are wearing the headset, to me, means that they're listening to something, trying to figure out what it is they're going to play and what parts of it they're going to let everybody else hear.
If you are just joining us right now on Local10.com, this is the sentencing of Nikolas Cruz. We heard from the state. We heard one witness just about 15 minutes ago, Brittany Sinich, an MSD teacher. She was in a first-floor classroom. No shots were fired into her classroom, but she did call 911, and we did hear that 911 call, which was really the first piece of evidence that we've heard, the first audio piece of evidence that we heard, and even just those few seconds were chilling. You hear her, you hear gunfire, and it was really heart-stopping.
It was compelling, and you could see the tears in her eyes just as before they were going to even play the call. She knew what was coming, and she was there. She acted and saved the lives of the students who were in her classroom with her by doing what they were all told to do, turning off the lights, get in the corners of the classroom, hide under the desk, don't move, Who knows where Cruz was at that point, if that action in fact saved the lives of all of the kids in her classroom. And you could just see the emotion on both her face and then which was actually brought to tears.
And the defense was asked if they would cross, and they did not. What could they possibly?
There was nothing they were going to do other than inflict damage on themselves by trying to get her to relive this again. There was a point well made by the witness. They introduced the exhibits they needed to introduce. There was no point in cross-examining that witness.
And now, right now, we are on witness number 2. This is Danielle Gilbert. She's a UCF student. She was a junior at MSD when this happened. She said she was in the classroom. She said that Cruz shot into her classroom. 4 were shot, one of them fatally. And she said she did take her camera out and she took some videos, and that may be what the attorneys are discussing now, either whether some of those videos can be shown in open court, in the public. I think that's something that they're doing right now. Is there audio from the courtroom, or have they turned that off? Not yet. Okay, so no audio yet. That means that they're discussing, and it looks like they're taking their headphones off. So let's take a listen. And Mike Satz, you can see, is putting his headphones back on. So there may still be some discussion. So once again, we've heard from one witness. We're in the middle of the second witness testimony, a student who took video. So the question is, will there be some of that video that we see or not?
Well, the jurors are going to see it. I mean, and that's what the whole exercise they were going through here. He showed her the disc. She identified the disc. She said that she'd viewed it before, that contained the video that she had captured. So now it would appear that they're trying to figure out either how to play it so that the jurors can see it, and if they are going to let the jurors see it, whether or not it's going to fall into that category of evidence that we'll show in the courtroom, but we're not going to show out to the rest of the world. That's what they're trying to figure out at this point.
So we're continuing to watch this. As you know, this is day 1 of the sentencing of Nikolas Cruz. Things have gone a little later than planned. Things started a little bit late this morning. There was an issue with a juror. There was an accusation that maybe that juror had spoken about the trial to somebody at an appointment. The judge ultimately said, after questioning the juror, and the juror denied it, I believe you, let's move forward. So that happened. And then we heard from Mike Satz, who is the lead prosecutor for the state, methodically talking about what happened that day on February 14th, 2018, mentioning not only the victims by names, the victims who were shot, but the injured. We don't hear a lot about the injured sometimes. And so names and ages, he named them both.
Yeah, and he went through it very methodically and very much setting the stage for him to show, just as he methodically went through it, what he's going to do to show that Cruz was methodical in how he went about doing what it was that he did. And, it's very important to the state to be able to share this audio and this video. Even that small snippet of the 911 call that we heard, you could hear the gunshots in the background. And that's what was going on there 4 years ago on Valentine's Day. And so now these videos that were captured by the student who's testifying are going to give another look inside of what was going on in that classroom. And again, they're using this to show just how premeditated, how cruel it was that things were taking place. You heard the student talk about the fact that 3 of her fellow students were shot at and injured, and 1 was also not only shot at, but died as a result of this. So this goes into just how cruel it was, not only to the victims, but to those other people who are sitting around and watching this take place.
Even the teacher who called 911 said that they were having fun, they were having a great afternoon, when she said she heard, quote, the loudest noise you could ever possibly imagine. She said she called 911, and at one point the dispatch couldn't hear her over the sound of the gunfire, and then they played that audio and we heard it for ourselves. It was chilling, and I can't imagine being a loved one or a family member in that courtroom right now listening.
And it's going to be particularly difficult for the parents of that student who was in that classroom who died to now be shown potentially video of what was going on. Due to the length of what they're going through now, it seems that they're either listening to the entirety of what these videos are to determine what the audio is that corresponds to it. Nobody's really talking. They're just listening
No.
and looking at some of the screens.
Right, and we are listening intently, by the way, in the control room. When they do turn that volume up, when it becomes public and open, we'll bring it to you again. But at the moment, they have their headphones on. And for those of you who are just joining us, this is really sort of the modern version of what you see as a traditional sidebar, right? It would be attorneys going up to the judge and speaking to her, but instead, because I think there are so many and because of technology, they're just wearing these headphones.
And there may be a transcript as well of whatever is heard over the video portion, the audio portion of the video, and because I see them flipping pages, so they may be looking to make sure that the transcription of whatever the audio was is the same transcription of what's taking place. And interestingly, if you can see, Cruz sort of has his hands buried, his head rather buried in his hands there while his lawyers are listening to what's going on. I can't even tell if he's got a headset on or not.
I don't think so. For the most part, he has not been engaged, although we did have one observer say that when the first teacher, Brittany Sinich, went onto the witness stand, he looked at her as though maybe he had recognized her as somebody that he knew or knew of, and then he quickly put his head back down. He, for the most part, has not been very engaged in this process, at least not today and not in the last few years.
No, and he, to some degree, maybe taking notes as to what's going on, thought he would perhaps be helpful to let his lawyers know, oh, that is so-and-so, somebody who was there. I think part of their strategy is to just have him sitting there and taking notes and interacting with them as little as possible, so that they can preserve whatever arguments they're going to make about his mental capacity at the time that the incident occurred. And again, what we're seeing here, this delay, not uncommon. They have to decide, whether or not what they're about to play for the jurors is what they agreed upon, whether or not this is exactly what was there. I would have thought that they would have gone through this exercise before, given the defense an opportunity to look at what's there, and so that we wouldn't have to have the jurors sit and wait, because much like we're sitting and waiting, the jurors are sitting and waiting, unless what's going on is that they're all hearing and seeing what's going on in the courtroom, and it's just the rest of us who are not.
Right. And I'm hearing a little bit of that white noise, so I think that still means that this is still a sidebar. We're still not quite ready yet. Is the judge not now?
She's got her back to us because she's concentrating on something.
Oh, I see.
Looking at a transcript or what it might be. And so it may be that they're comparing a transcript to the audio of what's on this video that was captured on the student's cell phone.
And as we said before, there were technical delays. There were sort of personnel jury issues. None of this is surprising. None of this is anything new.
No, it happens all the time. I don't think I've been involved in a trial, whether it's 1 day or 21 days, where everything goes as planned. There's always something that happens that you didn't expect to happen, and it's just something we deal with on a regular basis. One
thing that was mentioned to us, which I think is worth noting, is that this courtroom, this is the new courthouse in Broward County, and this courtroom is the courtroom of the chief judge who gave this up for this trial. More than 200 and some capacity in the audience is what I'm told, which is big. It's very big.
Well, they knew they were going to need a large courtroom to handle the victims and next of kin who were going to be there, and then the media that was being drawn to watch this. They've got to have a big enough courtroom for all these lawyers, and then a big enough jury box to handle a jury that's now at 22 jurors, including the alternates.
Who are seated, as Christina Vasquez says, in alphabetical order, so that there's sort of no delineation between who's an alternate and who's the main juror, so that it really kind of forces them all to sort of focus and pay attention and be part of the process.
Right. Everybody has to pay attention with the same degree of uncertainty as to whether or not they're on the main panel or whether they're part of the alternate jurors who might be called into duty at some point down the road should one of the main panel not be able to proceed.
And each juror, from what we understand, has his or her own monitor where they can sort of look at that evidence. You think of courtrooms and easels and big posters, and that is the way of the past, I guess.
Correct, not anymore. And a lot of it's because jurors expect the technology to have caught up with them. I mean, the student's answer here, Ms. Gilbert, she said herself, I don't know why, But the first thing I thought to do was to start taking video of that. It just seems to be a response that people have now because they have a phone that has a camera in it and can capture what's going on around them. She certainly knew something was going on that was not a good thing, but for her first reaction to be, I'm going to capture this on video, and now here, it's of a benefit to the state because they have that. As you heard Mr. Setz talk about before, there are cameras contained within the buildings, and we're going to get some of that video, but because simply of the noise and the repercussion from the shots being fired out of the weapon that caused dust to come down, some of the cameras got knocked out of commission, we weren't able to get that video from those sources, so we're going to get it from here. But again, he's painting a picture for these jurors. He's giving them details so that they can view this as if they were there, because they weren't. And so now he's giving them that opportunity, and it seems to be that that's what's going on here. And once they finally get through the preview of whatever they're watching or listening to, they're going to show it to the jurors, and they're going to be there as it was happening.
And as we know, the opening statement from Mike Setz, the chief prosecutor, painted that picture with words and descriptions of how the shooter went into the school, and now we may be listening to audio and video. So maybe at this point they figured it out. Let's listen.
States D for identification will be received as states 4.
Your Honor, and the last...
5, excuse me. Thank you. It's 5.
The last, thank you. The last is sensitive. The last video.
We have the sensitive
Okay.
police.
Oh, perfect. Okay, great.
Over here. Okay?
Nice. Okay.
Thank you.
Okay.
I said 5. I said 4, and then I corrected myself. It's states 5.
Can you hold, please?
police are here. We hear voices. I think so. It sounds like police are here. No, I don't know. These are police. We're okay now, though. Is he gonna get us out? Yeah, like shh. This can't be real. There's just glass everywhere.
Hey. Hey.
These are police.
Hey.
Idiot service. My phone's over there. It was on my desk.
Hey.
They're coming. They're coming. We're okay. There's glasses. They got him. Oh my God. Are you recording this?
Hey.
All right, guys. 3 down. 3 injured. Is anybody injured? Yeah. Shot. Where? Come here. You come up. Can you walk? Where were you shot? I need help. I need help. Somebody help. We got. Oh my God.
Logan, my desk is my water bottle. Can you get my phone? With the bag, with the water bottle next to the balloon. Yes.
Let's go, come on, let's go. Let's go. Come on, follow me, follow me, follow me. Okay, please. On the wall. Go, 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 go. On the street. All right, come on.
Okay, Ms. Gilbert, I want to show you State's Exhibit marked 3 that's been introduced into evidence. And if you'd be good enough to point out classroom 1213 for us. And do you have the, let me see, yeah, okay. Could you circle 1213? Thank you, okay. Ms. Gilbert, thank you very much. I have no further questions, Your Honor.
Advance, any questions?
No, no, thank you.
Okay, thank you, Miss. You're excused.
I'm getting it.
So that was witness number 2, Danielle Gilbert. She was a junior at MSD.
Dylan Kramer.
1213. We heard audio of some of the videos that she had taken, and they were gut-wrenching.
Absolutely gut-wrenching, and just you could see the sheer emotion from her when she finally broke down on the stand watching this again, from the parents sitting out in the gallery. Some of them had to walk out of the courtroom. You know, we're not in the courtroom, but you could just feel it and sense it here. And for those jurors who are seeing what's going on, this is driving the point home that the prosecution has contended all along. There's going to be very little cross-examination from the defense. There's not much that they can say to even call into question anything that these witnesses are testifying about. And it's just going to make matters worse for them.
That was an example of what Christina Vasquez, who's in the courtroom, by the way, had said is evidence that the jury is seeing all of it. We are just hearing the audio because of the graphic nature.
And at some point you have to wonder just how much more is the defense going to sit there and watch. You know, they've contested that there are enough aggravating factors there, so they're going to have to sit through all of it. But the cumulative effect, this is only witness number 2. And so far, it's just been devastating.
We know that some parents had left. We had seen the Guttenbergs. At one point, Jennifer Guttenberg holding her ears because you could hear gunfire, you could hear moaning. And I believe that this is witness number 3 taking the stand. So let's take a listen.
Good afternoon, Mr. Kramer. We don't get called Mr. very often because you're young, but that's what we do in court. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you, sir. You can put your hand down, and please state your full name and spell your last name for the record.
Dylan Henry Kramer, Kraemer.
Okay, Mr. Sachs, you may
Thank you, Your Honor. And Mr. Kramer, do you go to school?
Yes, sir.
And where do you go to school?
University of Southern Florida, Tampa.
Okay, could you lean forward so that the microphone can pick you up, okay? Thank you, sir. What year are you in?
I'm a junior.
And what course are you pursuing?
I am a studio art major.
Okay. I'd like to call your attention to
Mr.
when...
Sachs, 1 second. I don't think they can hear him. Can you turn the microphone off? I'm sorry? Can we move it closer to him?
This one?
Okay, if you would just lean in a little bit, please. Thank you.
Okay. So Where did you go to school on Wednesday, February the 14th, 2018?
Marjorie, Stoneman, Douglas.
Okay. And what year were you in?
A junior.
Okay. I'd like to call your attention to the fourth period that day. Dylan, do you remember what class you had?
Yes, sir. It was room 1214, Miss Seamus's History of the Holocaust.
Okay. And please tell us what you remember happening during fourth period.
We were in the hallway, we were in the classroom. We finished up with our work. Out of nowhere, we heard a very, very loud sound, assumably gunshots. We all ran to the corner of the room. Some went to the room next to the door. The other half of the class went to diagonal of the window. And we knocked down a file cabinet, tried to get behind it, get as many students behind it, and kind of just waited. And then I peered around the corner, and eventually the shooter started shooting through the window, and bullets were flying through. Ducking down, waiting 20, 30 seconds, and then it stopped, kept going on. And then I looked over, and 2 people were dead, and multiple people were shot.
Okay. And you said the bullets came through the window. Describe where this window was.
The window was in the door into the classroom, right in the middle.
Okay. And did you see anything through the window?
Yes, sir.
What did you see?
I saw the shooter.
What did he look like?
Wearing a hat, glasses, a vest, and I could see his gun.
And did you see the gun?
Yes, sir.
What did the gun look like?
A large AR-15.
Okay. So you said that 2 students were dead. Who were they?
Nikolas Cruz and Helena Ramsey.
Okay. And did you see anyone who else was wounded?
Yes.
Who was wounded?
Sam Grady, Sam Fuentes, Isabel Checker. I can't remember. Multiple people.
Okay. So tell us what happened after that.
We waited. I called the police. I called my parents, or texted my parents. I checked Nick's pulse, and I waited for the police to show up. Eventually they came through, cleared us out, took out the wounded first, and then basically just told us to run out of the building.
I'm sorry.
Out of the building.
And approximately how long did you wait before the police arrived?
Maybe 15 to 20 minutes.
Okay. And did there come a time where you viewed a video of what occurred?
Yes, sir.
And what did it show?
It showed a student in my classroom and the door where the shots were coming through, and you could hear the shots.
Okay. And did that video, that audio video, did it accurately and truly depict what you saw and what you heard?
Yes, sir.
On February the 14th, 2018? 100%. I want to show you State's Exhibit Mark E for identification, Mr. Kramer, and ask you if you could look at this drive for me.
Yes, sir.
And have you seen this before?
I have.
And did you watch what was on this video, this audio video?
Mm-hmm.
Did it accurately depict what you heard and saw on February the 14th, 2018?
Definitely.
Okay. Your Honor, I'd like to offer State's Exhibit E.
Mr. Wheeler, are you handling this witness? Defense?
Judge, same objections we had before.
Okay. Over the defense objection, State's Exhibit E for identification will be received as State's Exhibit 6.
May I play it, Your Honor?
Yes, the sheriff's office who was blocking some of the view has moved. Do you need them back?
I don't think so. No. I don't
Okay.
think so. Holy
So if you're just joining us online, we actually were just talking to our anchors on Local 10 on the TV side. We're sort of toggling back and forth because it is news time. Thank you once again for joining us on local10.com and our other social media platforms. I'm Janine Stanwood. This is our legal analyst, David Weinstein, attorney, former state and federal prosecutor. You've been such a great help for us today as we continue to watch. We had 3 witnesses so far that were being called by the state, and it looks like they are in a sidebar again. That explains the headphones that the attorneys are wearing.
Just before they cut to the sidebar that they're in the middle of, they were playing some additional audio. The victim who was up on the stand now, Mr. Kramer, who was also a junior, but he was in the 12-14 classroom, he was describing what he saw take place, and I thought that they were going to actually ask him to identify the defendant sitting in the courtroom today. Perhaps that's going back to my days where you're proving guilt and not penalty here. But, you know, he described what he saw happening, from putting the file cabinet in front of the window to see shots coming through the window and people being shot all around him. And that when he looked out the window, he saw Cruz firing the weapon through the window. And then they were playing some audio for him to listen to. I'm not sure what the discussion is they're having about the audio, why they had to go for a sidebar right now. But again, this is yet just the 3rd witness, and for the amount of evidence that's actually been introduced, just the devastating effect against the defendant and the ability of the state to show these aggravating factors is coming in through only the 3rd witness. And the state said that they're going to put on a case that's going to last weeks. And, you know, at some point, it just sinks in to these jurors that there really is no mitigating circumstance that's going to outweigh these aggravating factors. And perhaps that's why the prosecution has taken such a rigid position. We know that the victims' families have asked that that be the only penalty here. And again, hearing from 3 witnesses devastating testimony, this is why they've dug their heels in.
Absolutely devastating. And witness number 3, this Dylan Kramer, who spoke and described looking out of the window of his classroom door that was shot. He was the first witness who said he saw the shooter. He said not only did he see the gun, but he saw the shooter. The other witnesses heard the gunfire, they heard the commotion and the carnage and saw it. The second witness, as you know, videotaped it, so we heard the audio of that, which was absolutely devastating. But Dylan Kramer was the first of the witnesses who definitively said that he saw the shooter, and now they are discussing in court. Now, is he still on the stand? Is Dylan still on the stand? Okay.
He appears still to be on the stand. There was some pointing that was going on in the gallery as to certainly what they were seeing out there. Perhaps there was a concern about what was going out across the web and what was being shown, perhaps some objection by the defense. We can't tell for sure until they come back out of the sidebar as to what they're arguing about.
Our Christina Vasquez, who is in the courtroom right now, said that when the witnesses took the stand, especially witness number 2, Brittany, who we heard, you know, those videos and we're listening to the audio from the videos. Christina said that Cruz really appeared very distressed, rubbing his eyes. You know, it was just, you know, sort of one of the times that we have actually seen, you know, some reaction from Cruz, who for the most part has had his head down. He's had his hand covering his head, but that got a reaction from him, at least hearing the audio, and perhaps seeing the videos as well.
I mean, we heard in the opening about a fellow student or some former student who he saw at the McDonald's afterwards, who he knew he was trying to get a ride home from. Both of these last 2 witnesses were juniors at the time, so it's entirely possible that he was classmates with one or both of these 2 witnesses who've now testified, and it's really coming at him to see these people sitting in front of him, people who he had planned, you know, potentially not to be there. And certainly you can see the emotion. He's got his head buried in his hands, you know, right now, whether or not that's just simply a reaction or whether he just, you know, can't take the gravity of what's going on here.
This has been such a long day for these parents who listened to the very powerful opening statement by Mike Satz, taking you through Cruz's movements inside Building 12 and at MSD, and then just to start, you know, hearing from these witnesses and seeing the video and hearing the audio. And it sounds like maybe we are back with this witness on the stand. Let's take a listen.
Can you see the diagram in front of you? It states exhibit Mark 3. Can you see it?
Yes, sir.
Would you please circle classroom 1214 where
I
you
can't
are?
see it.
What?
Oh, we went on sidewalk.
All right. Do you see it? You know how to do it?
Probably. Should 1214?
That's it. Okay. All right. Thank you, Mr. Kramer. Your Honor, I have no further questions. Thank you, Mr. Kramer.
Defense, any questions?
No, Your Honor, thank you.
Okay, ladies and gentlemen, thank you very much. We're going to take a 15-minute recess at this time. Please do not discuss the case among yourselves, and we'll be back with you shortly.
Okay, so you heard that. That was witness number 3, Dylan Kramer. Now they're taking a 15-minute recess to come back. Will we go back to Dylan?
No,
he was done.
He was done. There was no cross-examination. The extent of his testimony was heard. The audio they wanted to play was heard. And, you know, he circled his classroom on the same pictures that others have circled their classroom. And so now they're going to move on to witness number 4.
We're going to continue to watch this in about 15 minutes. We will be back online and, of course, on our social media platforms. So we're going to take a quick 15-minute break, as they do in court, and we'll be right back.
Wheeler adopted.
Welcome back. I'm Janine Stanwood, and this is the sentencing of Nikolas Cruz. Joining me is our legal analyst, David Weinstein. We've already heard the openings from the state from 3 witnesses, and probably one more at least.
At least one more, depending upon how long or short the next set of witnesses are going to be.
Let's take a listen.
Indicating a description of the firearm that he believed that he saw, as well as the individuals that he witnessed being murdered. When the Snapchat videos were published to the jury at the highest volume possible, and it was also displayed to the gallery.
Let's not say things like that unless you know what we're about.
I do believe that the state admitted, he said he had it at the highest volume possible and then he had to reduce it. The video was also displayed to the gallery. It was during that time that one member of the victim's family or friend made an audible an audible response saying, "Turn it off, turn it off." It was at that time that the court turned on the white noise. The Broward Sheriff's Office followed the instructions that the court had previously given them, which was that any individual who is disruptive or has an emotional outcry should be removed by the Broward Sheriff's Office. Judge, it is necessary to declare a mistrial in this case because the jury was present during all of this. It would bring unfair prejudice to Mr. Cruz and Harris fair trial rights. It could inflame the jury, garner additional sympathy and anger towards the client. A denial of this motion would violate Mr. Cruz's right to due process guaranteed by the 15th and 14th Amendment of the United States Constitution, as well as Article 1, Section 9 of the Florida Constitution, and 6th and 14th Amendments of the United States Constitution, Article 1, Section 16 and 22 of the Florida Constitution, as well as the 9th and 14th Amendments of the United States Constitution, equal protection and basic rights guaranteed by the 14th Amendment of the United States Constitution. Based on the foregoing reasons, the defense moves for a mistrial as the prejudice to Mr. Cruz by what happened in this courtroom in front of the jury would render this court to provide Mr. Cruz with the ability to have a fair and impartial trial. This is upon consultation with our client, and he is in agreement.
Okay, first of all, my desk is elevated, and I could not see who was speaking because the person is in at least the 6th or 7th row, which I would say is at least 150 feet from the bench. That's number one. Number two, I couldn't hear what the person said. In the abundance of caution, I asked the white noise be put on. But somebody shouting one thing when you don't see them or you can't hear exactly what they're saying is not even close to grounds for a mistrial. The jurors, I don't even think any of them looked. As far as the volume being on the loudest volume possible, that's on grounds for a mistrial. I asked the state next time turn it down a little bit, but so that people can see it. But your motion's denied.
I understand the court's ruling that as an officer of the court, I can make a representation that I heard the individual in the gallery of this courtroom say twice, "Turn it off, turn it off."
Do you want to say anything on state? I advised the lawyers what the witness said because the sheriff's office told me.
Your Honor.
And that's the only reason that I knew. The defense did not tell me what the witness said until just now, as an officer of the court or not.
Your Honor, the state agrees with the court's ruling, and the volume was very loud. It was extremely loud, and I think that the witness, or not the witness, turn it off, turn it off. The volume was so loud as if to turn the volume down, Your Honor. That's what it could be attributed to. And we agree with the court's ruling. The motion for mistrial should be denied.
All right, State, do you have another witness to call?
Yeah.
Okay, go ahead.
Jury's not here.
Oh, can you bring him in, please? Thank you for reminding me. Small oversight.
Okay, well, that was a development. The defense asking for a mistrial. They initially said that the volume was so loud and that there was a member of the audience who objected, and that all happened while the jury was there. And they said that was grounds for a mistrial.
The argument that they were trying to make was that a member of the audience heard the sound from the video that was being played and said, turn it down, turn it down, turn it down, and then ran out of the courtroom. And the inference they were trying to draw was that it was so prejudicial to the jury that how could they view their client as not having satisfied, again, one of these aggravating factors. I think that their argument would have had more weight in a guilt phase because you're trying to determine guilt or innocence, and those types of things have more of a detrimental effect during the guilt or innocent phase. But here in the penalty phase, I don't know that it rose, and I agree with the judge that it didn't arise to the level of her to call a mistrial on this. But again, points out the importance of the people who were in the gallery of maintaining their composition and not letting their emotions affect them in a way that's going to negatively impact on the actual trial.
Which would, of course, be extremely difficult considering the nature of what we are seeing and hearing. The judge said where she is sitting, she's elevated. She could not see that particular loved one or family member leave. And so that just means that now we move forward to the next.
It won't be the first time or the last time that such a motion is going to be presented by the defense, nor the judge going to have to rule on something like that.
It sounds like they're going to call their next witness, I believe. Let's take a listen. Okay, the mics are open, but nothing is happening quite yet, so we will wait. This could very well be the last. There we go. The jury is now walking in. All right. This could be the last witness of the day.
Depending how long the testimony is and how much longer they want to go. It's been a long day. Despite there not being that much actual in-courtroom activity, the judge may be willing to cut it short at 4:30 or so. That's how long it takes.
There have been some delays, some technical issues. We've listened to the opening statement from the state and 3 witnesses so far. So we do understand that now, once the jury comes in and sits down, they will call their next.
Thank you for your patience. The jurors are present. State, call your next witness.
Thank you, Your Honor. Maximo Rosario.
Good afternoon, sir. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
My name is Maximo A. Rosario. Last name is Rosario.
And Mr. Rosario, what do you do for a living?
I currently work for the Broward County School Board.
And what do you do for the Broward County School Board?
I'm the current director of classroom technology.
Okay. And how long have you had that position?
4 years.
Are you familiar with Marjorie Stoneman Douglas High School?
I am.
And how are you familiar with it?
I was assistant principal there for 10 years.
How long were you an assistant principal?
10 years, over
10 years?
over 10 years.
Okay, when did you start as an assistant principal?
I was appointed in December of 2007.
Okay. Did you have anything to do with the video surveillance system that was set up at Marjorie Stoneman Douglas?
I did.
Please tell us what part you played in it.
So I've done the training, and I was trained by district staff on how to use a system that was installed at Marjorie Stoneman Douglas.
Okay. And when did that take place, sir?
So there was a system already in place. So it was upgraded as time progressed and new buildings were constructed.
Okay. So in February of 2018, were you familiar with how the system operated?
Yes.
And how did it operate?
Basically, a recorded motion sensor activated and recorded 24 hours a day, 7 days a week.
Okay. And was there a server that controlled everything?
Yes.
And where was the server located?
The main server was located at the media center in the back room, locked behind a cage.
Okay. And how is the server secured?
So it was a room in the back of the media center. Only certain staff had access to that particular room. Inside that room, there was a locked cage with a padlock, and only myself and the microtech had access to that particular lock cage.
Okay, so it was secure.
Yes, sir.
So, and that's the way it existed on February the 14th, 2018?
Yes, sir.
Okay. How does the system, you said the system is motion activated. How does that work?
Basically, when activity happens in front of a particular camera that was distributed around the school, the video surveillance system will start recording that particular activity, whatever it may be.
Okay, and if there's no movement, it doesn't record?
It does not.
Okay. Have you ever done downloads from the server?
I have, yes.
And how do you do that?
Basically, we have a local computer where you can then export from the server into a local hard drive and then transport it to either at that time a CD or a flash drive.
Okay, and have you done that prior to February the 14th, 2018? Had you
Yes.
done that many times?
Yes.
Had it always been proven to be accurate?
Yes, sir.
Time, date?
Correct.
The cameras in the 1200 building, you familiar with the cameras in the 1200 building?
I am.
Were you instrumental in upgrading those cameras?
So they were the newest cameras in the building when they were installed. Our building was constructed in 2009, and they have put in the higher resolution cameras in that particular building.
Okay. Let me show you now State's Exhibits J and I. I've shown these to the defense, Your Honor.
Okay.
J and I for identification. Let me just show you first I, Mr. Osera, if you don't mind taking a look at that. Do you recognize what that depicts?
Yes.
Does that accurately and truly depict the east entrance to the 1200 building as it existed on February the 14th, 2018?
It does.
Okay. And I show you State's Exhibit J and ask you, does this photograph, State's Exhibit J, truly and accurately depict the west side doors that existed on February the 14th, 2018?
It does.
Thank you. Your Honor, I'd like to offer I and J.
Is there any objection?
Oh, ma'am.
Okay, states I for identification will be received as states 7, and states J for identification will be received as states 8.
Okay, I want to show you first, Mr. Rosero, State's Exhibit 7. Can you see that on your screen?
I can.
And what does this depict?
That is the east side of the 1200 building.
Okay. And there's 2 double doors I see there, right?
Correct.
Where do they lead to?
Those lead straight into the corridor where the classrooms are.
Okay. On the first floor, obviously.
That's correct,
Okay.
yes.
And how about the door to my right of it?
So that door goes right into the staircase.
Okay. And I'll show you State's Exhibit number 8. And can you tell us what that depicts?
Yes, that's the west side of the 1200 building, front entrance, first floor.
Okay, and those double doors, where do they lead to?
They lead to the main hallway where the classrooms are opposite of the other.
Okay, on the first floor, obviously.
On the first floor, yes.
And how about the door to the right of
The
that?
door to the right leads straight into the staircase.
Okay. Now I want to show you State's Exhibits K, L, and M. Mr. Osera, if you'd be good enough to take a look at these exhibits.
Okay, this one is the west side of the front entrance that you just showed me. That's the inside part of the corridor.
That's K.
This is the center of the hallway as you come into the first floor.
Okay, and that's L.
And this is the interior side of the east door side of the 1200 building.
And they accurately depict the east, central, and west entrance, the east and west entrances in the central part of the first floor hallway?
They do.
And did you depict where the cameras are?
I can, yes.
Do they depict where the east, central, and...
Yes, so the first camera is right over the double doors, as
Okay.
you made. The camera in the center aisle is right over the bathroom doors, past the exit sign, past the smoke alarm or detector that's there. The camera, you can see it facing the east. And then on the east end, you can see the camera right over the door again, facing in.
All right. Your Honor, I'd like to offer States Exhibits K, L, and M.
Is there any objection?
No.
Okay, states K for identification will be received as states 9. States L for identification will be received as states 10. And states M, as in Mary, for identification will be received as states 11.
Thank you, ma'am. Okay, Mr. Rosario, now I want to show you States Exhibit marked 11 that you have identified as, I think you said it's the east entrance door, the interior?
That's correct.
Okay. All right. Is that what that is?
Yes, sir.
All right, could you, do you know how to use, I say do you know how to use because I don't. Do you know how to use the, where you can circle it with, that's it, okay. What is that?
That is the camera pointing
Okay.
west in the first floor.
And it's facing west?
Yes, sir.
Focusing west, okay. And that's States Exhibit 11. I'm going to show you States Exhibit 10.
So that is the center view, and the camera is located. Oh, you moved it.
No, I'm sorry. Oh.
Okay, so camera's right there in the
Okay.
bathroom,
All right.
facing east.
Okay. And showing you west or east?
Looks like it's facing east.
Okay. And here's States Exhibit 9.
Okay, this is the west side of the building. The camera is located right there.
Okay. So all the three cameras that you identified, east, west, and central, is that the way it is for all three floors?
Yes, sir.
Okay. And showing you States Exhibits N and O. And ask you, Mr. Rosario, if you can identify those.
So these are staircases. I couldn't tell you which one is east or west, but these are the first landing and the second landing. They were both identical, both on the east and the west side of the staircases.
And they show where the cameras are?
They do.
Okay. And did they accurately depict where the cameras were, whether it's east stairwell or west stairwell, as it existed on February the 14th, 2000?
It does, yes.
Your Honor, I'd like to offer States Exhibits O and N.
Is there any objection? Did you say no?
No, Judge.
Okay, thank you. States N, as in Nancy, for identification will be received as states 12, and states O for identification will be received as states 13.
Mr. Rosario, I'm now showing you States Exhibit 13. Can you see that okay?
I can.
Okay, and would you point out for the camera for us?
Camera's located right there.
Okay. And States Exhibit 12.
Camera located
Right there, okay. And that's the way the cameras were on both the east and the west stairwells, correct? Okay. How many people do you feel you trained on the surveillance system when you were the assistant principal at Marjorie Stoneman Douglas?
Roughly maybe 20, 25 different people.
Okay. Okay, thank you, Your Honor. Have no further questions of Mr. Rosario.
Thank you. Defense, any questions? Okay, thank you, sir. You're excused. State, call your next witness.
Edward Kessler. Appreciate it.
So that was Max Rosario. He was a classroom technology director, also at one point an assistant principal at Marjorie Stoneman Douglas High. So he was basically looking at different angles of the 1200 building and surveillance cameras to authenticate them.
A foundational witness. They want to establish what the buildings look like, the ingress and the egress, where the doors were located, and then where the security cameras are, because at some point they're going to play the footage from those cameras. And so these will give the jurors an overview of where those cameras were located, what it is they were looking
Raise
at.
your right hand. Do you solemnly swear or
All right,
affirm
let's
the
listen
testimony you're about
to
give
witness number 5.
the truth?
Yes, sir.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
James Edward Kessler, Kessler.
State your name prior.
Thank you, Your Honor. And your occupation, sir?
I'm a systems analyst with the School Board of Broward County.
And what is your training and experience?
My background is managing the video surveillance systems at the sites.
Okay. And are you familiar with the surveillance system that exists? First of all, how long have you been doing that?
I've been in that capacity approximately 5.5 years.
Okay. And what are you doing now?
Same.
Same thing? Were you familiar with the surveillance system that existed in Marjorie Stoneman Douglas High School on February the 14th, 2018?
Yes.
And how did the system operate?
It's a computer-based system. There's a large server which sits on campus, which contains all the video recordings. The cameras connect to the computer network, same as phones and computers and other things. And the cameras and the server communicate, and once they sync up, anything that the camera sees is automatically sent to and stored on the server.
Okay. And how does the system work? As far as, is it motion activated?
Yes.
Yeah. Okay.
So the system is typically set up to record on motion, so that we're not recording empty hallways in the middle of the night or on weekends when nobody's around.
Okay. I'd like to call your attention to February the 16th, 2018. Were you working that day?
Yes, I was.
And did you have occasion to go to Marjorie Stoneman Douglas High School?
Yes, I did.
Okay. And when you were there, did you have an occasion to meet with the FBI?
Yes, I did.
And did you go to the server room?
Yes.
Do you remember where the server room was?
Yes.
Where was it?
Second floor, back of the media center.
Okay. And do you remember how it was secured?
Yes. So there's a large room that has a chain link fence cage within it, and the server and the network equipment was in that chain link room.
Okay. I'd like to show you I want to show you State's Exhibit marked P for identification, Mr. Kessler. Can you identify that?
This is a property pass that I and the FBI signed when they took possession of the server.
Okay. And tell us how that transaction occurred.
We received a subpoena, a warrant.
No. How did it physically go?
We did a normal shutdown on the server, like you would any other computer. Disconnected all the cables from it, pulled it out of the rack in which it was installed in, and physically put it on a table and handed it to the FBI.
Okay. And that's a property receipt for the server?
Yes.
Okay. And let me show you. And the server had a serial number?
Correct.
And what is the serial number?
JFK80M2.
Okay. And showing you State's. State's exhibits Q, S, and R. and ask you if you can identify those photographs.
These are pictures of the actual server that was removed from the site.
And given to the FBI.
Correct.
Okay.
The serial number matches the property pass.
Okay, thank you very much, Mr. Kessler. Your Honor, at this time, I'd like to offer State's Exhibit P, property receipt, and State's Exhibits Q, R, and S, the photographs of the server.
Mr. Wheeler, is there any objection?
No objection, Judge.
Okay, states P will be received as states 14. States Q for identification will be received as states 15. States R for identification will be received as states 16. And states S for identification will be received as states 17.
Thank you, Your Honor. I have no further questions of Mr. Kessler. Thank you, Mr.
Okay,
Kessler.
Mr. Wheeler, any questions?
No, Judge.
Okay, thank you, sir.
Thank you.
You're excused. State when you're ready. Call your next witness, please.
Okay. Carlos Castillo.
So that was our fifth witness. That was James Kessler. He's with Broward County. He's a systems analyst. You're saying, David, he's a foundational witness to sort of show chain of custody of evidence.
In order to get in the video surveillance footage, they're going to need to establish where it came from. So he's at the beginning end of that. He told them about the servers, where they're located, identified the security serial numbers in the servers, and that allows the rules of evidence to be complied with. And so now this is perhaps the FBI agent who took custody of the server from him and then downloaded that information. So now we'll get to the point where they're going to try and introduce the videos.
Well, we'll see who this witness is. Maybe perhaps it is the FBI. Let's take a listen.
Thank you, sir. You can put your hand down and be seated. When you're seated, please state your full name and spell your last name for the record.
Carlos M. Costello. Costello is Castello.
And what's your occupation?
I am retired.
I know. When did you retire?
I retired at the end of 2019. Prior to that, I was employed as a special agent with the Federal Bureau of Investigation.
Okay. And how long had you been a special agent with the FBI?
Approximately 31 and a half years.
Okay. I'd like to call your attention to February the 16th, 2018. Do you remember that date?
Yes, I do.
And did you have an occasion to respond to a certain location?
I did.
And where did you respond to?
I responded to the Marjorie Douglas High School in Parkland.
Okay. And did you obtain anything when you went to Marjorie Stoneman Douglas High School?
I was sent there to take custody of the video server at the school.
Okay. And I'd like to show you State's Exhibit Mark 14 that has been identified as a property receipt for the server. Do you recognize that?
Yes, sir. This is the property receipt I filled out for receipt of the school video server.
Okay. And did you sign it?
And that, yes, my name, my signature on there.
And has a serial number?
It does have the serial number for the server, yes.
Okay. And now I show you State's Exhibits Marks 15, 16, and 17 that have been identified as the server. Do you recognize those photographs?
All right, this first photograph shows the 1B1 item number, which is the item number for the server. JFK80M2 is the serial number for the server. That's the second photograph. And then the last photograph is sort of the back of the server. It shows it's a PowerEdge R530 server, which is consistent with the server that was seized.
Okay. So the FBI took custody of the server.
That's correct.
And where did you all take it to?
It was eventually taken over to the federal building over in Miramar, Florida.
And
the
who?
FBI
I'm
building.
sorry.
Yes. No, I'm sorry. Go ahead.
No, I interrupted you.
No, we took the server was taken by one of the other examiners to the FBI building in Miramar, Florida.
And who was that?
That was Gaston Nieves.
Okay. And he was with you when you collected the server, correct?
That's correct. Yes.
Okay. Thank you, Mr. Castillo. Appreciate it. No further questions, Your Honor.
No questions.
Thank you, sir. You're excused.
Thank you. Thank you.
I have another witness, Your Honor.
Okay.
Yes, go on, you guys. No.
Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you, sir. You can put your hand down and be seated. And when you're seated, please state your full name and spell your last name for the record.
Gaston Nieves, Nieves.
You may inquire, state.
Thank you, Your Honor. Mr. Nieves, what do you do for a living?
I'm a digital forensic examiner for the Federal Bureau of Investigation.
And how long have you been doing that?
I've been a forensic examiner for 18 years now.
Okay. And what is your training?
I have a bachelor's degree from Florida International University in Management Information Systems. I also have a master's degree from Florida International University as well in Management Information Systems. I'm certified by the FBI to do forensics on Windows machines, Macintosh machines, cell phones, Linux and Unix systems. I also have certifications that are from the SANS Institute, which is like an independent organization that does cybersecurity training. So some of the certifications I hold from them are the GX Certified Forensic Analyst, GX Certified Forensic Examiner, Advanced Smartphone Forensics, as well as Incident Handling.
Okay. And you indicated that your title is Senior Forensic Examiner?
That's correct, sir.
Okay. And do you handle digital forensics?
Yes, sir.
What is digital forensics?
Digital forensics involves collecting, preserving, and analyzing and extracting digital evidence, meaning anything that could come from a digital device. It could be a laptop, it could be a server, it could be a desktop computer, a cell phone, an external hard drive, a thumb drive, cameras. So anything that stores information in a digital format, we're tasked with analyzing those sort of items and extracting data in order to assist with the cases.
Okay. And the process that you just described, how many times have you done that in your career?
I've done probably over 1,000 examinations.
Okay. Mr. Nieves, I'd like to call your attention to Friday, February the 16th, 2018. Did you have an occasion to respond to a certain location?
Yes.
And where did you respond to?
I was asked to respond to Marjorie Stoneman Douglas in reference to providing assistance with a search warrant to collect the video surveillance system from the high school.
Okay. And who were you with?
I was with Special Agent Carlos Costello.
Okay. Mr. Nieves, I'd like to show you State's exhibits number 17, 16, and number 15, sir, and ask you if you can identify that.
Yes, these are pictures of the server that was collected on that date.
Okay, and when you collected the server, Mr. Nieves, what did you do?
I was assisted by Mr. Kessler, and one of the things that we did before seizing the server was changing the passwords on the server so that we would be able to access the system in an easier fashion after we would have seized it. And he escorted us to the library, and within the library they had the data center. And within the data center there was a cage that had all the different servers. So he identified the server that it was. We changed the passwords as we needed to, removed it from the cage, and then they gave us a cart, and we did the necessary paperwork for chain of custody purposes, and then we rolled it out.
Okay. And when's the next time you saw the server? Did you take the server somewhere?
So that night, I took the server back to the Miami field office of the FBI, and on Monday morning was when I started working on the server once again.
Okay.
As far as starting the extraction for what had been requested.
Okay. And let me show you now State's Exhibit Mark T for identification, and ask you, Mr. Davis, if you can identify this.
This is the solid storage drive that contains the video that was extracted from the parking server.
Okay, and how, the server contained a lot of information, right?
Yes.
Okay, a lot of hours.
Yes.
Did you narrow it down when you extracted it to get this exhibit?
Correct. This exhibit contains 6 hours on the date of the incident on February 14th, 2018. And it runs from 1 p.m. until 7 p.m.
Okay, and did you hand this exhibit to someone?
Yes.
Who did you hand it to?
His name was Ron from Broward Sheriff's Office.
Ron Lowther, is that
Yes,
familiar?
sir. That's correct.
Did you also make another video just like that you sent to Vigilon, to Dan Booth?
Yes.
Do you know who Vigilon is?
Vigilon is the manufacturer of the surveillance system that was installed at Marjorie Stoneman Douglas.
Okay. And did you initial that exhibit in front of you?
Yes, I did.
It's exhibit, I'm sorry. Memory's bad. Exhibit T?
Yes, sir.
Okay. And the hard drive that you sent to Vigilon Dan Booth, did you initial that also?
Yes, I did.
Okay. Your Honor, I'd like to offer now State's Exhibit T.
Okay, States T for identification will be received as States 18, 1-8.
Thank you. Your Honor, I have no other witnesses today.
Okay.
Dan Booth from the Vigilon won't be in town until tonight.
Okay.
Would it be all right with defense and the court, instead of bringing Mr. Neves back to identify his initials in that hard drive, we can agree he signed that?
I don't have a problem with that, Judge.
Okay.
Okay.
Okay. All right. If there's any problem, Mr. Neves, I'll call you, but thank you. Thank you.
Thank you, Mr. Sets.
No questions.
Mr. Wheeler, do you have any questions?
No
Do you have any questions?
No questions.
Okay, thank you, sir. You're excused.
Thank you, ma'am.
Okay, ladies and gentlemen of the jury, so I told you our goal would be 5, sometimes a little earlier, once in a while maybe a little later, but today we're ending around 4:30, so that's good. We're on schedule. I'm not keeping you late like I did a few times, and I apologize again for that. So for tonight, please leave your belongings, not your belongings, but your notepads behind. Please remember, and you're going to be able to probably repeat this verbatim at the end of the trial, because I'm going to tell you so many times, but remember, you may not have any discussion of any sort with friends or family members about the case or the people and places involved, and this includes even your closest family members. They may ask questions of you or make comments to you. You may not discuss what goes on in here in the courtroom with anyone whatsoever, even your spouse, your grandmother, your anybody. You cannot discuss what goes on in here, and this order remains in effect until I excuse you at the end of the trial. So please remember that. Also remember that if for some reason someone were to approach you about this case, whether it be someone you know or otherwise, tell them you cannot discuss it and report it immediately to me. Okay, for tonight, have a safe drive. The Sheriff's Office is going to see you to your parking area, and for tomorrow we're going to follow the same procedure where I'm going to ask you to please be here at the same time, 8:30. It takes a while. I know you all are having to go through 2 screening processes. I apologize for that, but we're trying to accommodate you and make it as quick and efficient as possible. So we'll follow the same procedure for tomorrow. I do know that some of you had asked when we were calling making the reminder phone calls about your jury service. Some of you had asked if you could bring snacks, and that's absolutely fine. You have that jury room back there, and if you want to bring snacks, coffee, anything that you want to bring, that's fine, so that when you're on a break, you can utilize your whatever you brought from home. Is there any questions about the procedure or parking or times or anything to that effect? Okay, you all are excused. Thank you very much, and I'll see you tomorrow.
So court is done for the day. The state called 7 witnesses, and they decided to wrap up for the day. One more witness, who is, I believe, a BSO deputy, will hear from that person tomorrow because they're not in until later. These last few witnesses, David, you were saying these are foundational witnesses to show the chain of custody of some of this video.
In order to get evidence into any courtroom, you have to comply with the rules of evidence, and that means showing that the evidence is authentic, that it is reliable, that it's relevant, and it satisfies certain criteria in the rules of evidence. Often defense will stipulate that that is exactly what's going on here. However, in this particular case, with the state seeking the death penalty and being unwilling to waver on that, the defense is not going to be stipulating to much of anything. You certainly saw them not ask any questions on cross-examination and certainly not object once they've laid the foundation, but they're going to make the state go through the steps that they have to go through to introduce each and every piece of evidence.
And perhaps tomorrow, when we start off the day, then the state is able to start off with this video that we may be seeing.
Well, they have one more witness to call in the chain of custody to establish how it was downloaded and what was done with it, how they narrowed down the time frame. You heard from the last witness that it was footage from 1 p.m. to 7 p.m., and so we know that not all of that is certainly relevant, but they're going to talk to that witness and get him to narrow it down, and then they're going to play the video.
It's been quite a day. Opening statement was very powerful, and of course we did hear some of the audios from some very gut-wrenching videos from at least one Marjorie Stoneman Douglas High student. We are going to be continuing to watch this. Of course, you can find a full wrap-up on Local 10 as our newscasts continue, and we'll be right here first thing tomorrow morning as court begins again. We'll see you then.
Cab driver asked the male passenger to stand outside. At that point, he demanded that the cab driver bring him back to the original location. Surveillance video shows that the male subject and the cab driver begins to argue.
The weapon isn't visible in the video, but the man appears to shift in his seat. Moments later, that cabbie is yelling in fear.
Are you pulling a gun on me, man? Please, man, don't kill me. Don't kill me, man. Don't kill me. Are you on camera, man? Please. Don't hit me, man. Don't.
The nervous driver crashes at slow speed and the man exits the vehicle.
Put a gun on me.
Thankfully, the cab driver was able to leave the area unharmed and call 911.
All right, so BSO releasing that video with those clear images of the passenger in hopes that someone recognizes him. If you know who he is, call Broward, the Broward Sheriff's Office. You can also call Broward County Crime Stoppers at 954-493-TIPS. We're live in North Lauderdale. I'm Leanne Morejon, Local 10 News.
All right, Leanne, hope somebody makes that call. And turning now to the penalty phase for Nikolas Cruz today, day one of testimony, emotional testimony, as jurors decide if the MSD shooter should be sentenced to life in prison or death.
Yeah, court just wrapped up for the day. As you said, extremely emotional, very tough testimony to listen to. Let's get right to Janine Stanwood. She joins us now with legal analyst David Weinstein. Janine, break it down.
Well, court is now in recess until 9 a.m. These last few witnesses that we heard from, you were talking about the fact that they are sort of foundational witnesses to establish the chain of command of that server, because we may be seeing some video tomorrow.
They were setting the stage and establishing the foundation to admit the surveillance video that you heard Michael Satz talk about during his opening statement, that you were going to see Cruz enter the classrooms, you're going to see him enter the building, you're going to see some of the video from the shots that were fired. In order to get that evidence in, you have to lay the foundation for it, sort of the nuts and bolts of what we don't see go on in the courtroom, and that's why these witnesses had to be called. That's why they testified. They set the stage for a witness tomorrow who will come in and say, yes, that's the video I downloaded, and now they're going to publish it.
But what some of the most gut-wrenching testimony that we heard was from witness number 2. That was Danielle Gilbert. She was that UCF student who was a junior at MSD, who was in room number 1213 when she started hearing shots fired, and she said it was her instinct. It's such a modern thing, right, to pull out your phone and to start taking video. And she is, you can see her, she's on the stand. She got very, very emotional. And then at one point we did hear the audio of some of that video that was played in the courtroom. And it was really just gut-wrenching. And some of the members in the audience, we saw the Guttenbergs, we saw Tony Montalto and his wife. It was just heartbreaking for them. At one point, I think, you could see people holding their ears because it was just so hard to hear.
And for some people, this was the first that they'd actually heard. We've all heard about what happened. We'd heard the horror story as to what was taking place. We saw the video of the students rushing out of the school.